There we go. All right. Well, everyone, welcome to the championship round of the 2022 Colorado High School Mock Trial Championships. To the two teams that are here, congratulations. It was a hard-fought battle. We had some amazing competitors, some very tight rounds, and I think basically our two best teams have risen to the top. Congratulations to both of you. What we'll go ahead and do is we'll get started with the trial. And let me first check for our plaintiff side. Are you ready to proceed?
Yes, Your Honor.
All right. And for the defense side, are you ready to proceed?
Yes, Your Honor.
All right. What I want to do is, before we get started, just because this is the championship round, we've assembled a group of scoring panelists. It's a slightly larger panel to make sure we cover all the grounds. And they're all individuals with exceptional backgrounds and a lot of experience in terms of watching and judging and participating in trials. I'm going to go ahead and let them tell you a little bit about themselves. And I'll go ahead and start on my sheet, who's in the upper left. It's Judge Eric Johnson. Judge Johnson, if you tell our participants a little bit about yourself.
Good evening. Back when I was in high school, they didn't have mock trial. I was Lincoln Douglas debate. Then went to Tulane Law School, where I did a lot of moot court activities in law school. After that, I was a prosecutor in the 17th and 1st Judicial Districts for about 15 years. Then for about another 15 years, I was an immigration lawyer before being appointed to the bench. So now I'm on the bench in the Denver District Court.
Perfect. Thank you very much. I'll just keep going across the top. Next is Judge Ted Tao. Judge Tao, if you could tell us about yourself.
Good evening. I am currently on the Colorado Court of Appeals, which is the intermediate appellate court that everyone has a right to appeal their case to if they lose. I've been there about 4 years after 7 years as a trial judge in Brighton, following about 7 years in prosecution, 3 years doing some lobbying at the legislature, and 6 years as a labor lawyer. Judge Johnson and I actually were prosecutors together, so we've known each other for 20 years. And I'm excited to be able to watch you guys today.
Excellent. Thank you. And we'll next go to Luke Ritchie. Mr. Ritchie, if you could tell us about yourself.
Hi there, I'm Luke Ritchie, and I'm in private practice here in Denver. I grew up in Southern Colorado in a small town called Canyon City. And when I was in high school, we didn't have mock trial. So I've enjoyed following it since I've become interested in the law. And I want to congratulate all of you out at the gate and just say it's wonderful that you've all made it here. I graduated from University of Colorado in Boulder undergrad, and then from the University of Denver Law School, and have been in private practice since then. I practice at Moy White now. I'm a partner in the trial group, and I focus my litigation and trial practice on complex business and securities disputes. I'm also the current immediate past chair of the Colorado Bar Association's litigation section, and I am the vice chair of the Colorado Bar Association's business law section. I'm really pleased to be here.
And our litigation section has made this possible. They're the ones that fund the high school mock trial program. So we greatly appreciate the guidance and steerage we've had from that committee. Thank you. Let me also go to Judge Ross Buchanan next.
Good evening, everyone. My name's Ross Buchanan. I grew up in Boulder. I too did not have any mock trial experience up until law school, actually. I went to undergraduate at a little college in California called Occidental College, went to Northwestern Law School. Before I was appointed to the bench, I practiced, I had a general civil trial practice. I represented, the main thing I did was represent people in product liability and personal injury matters. But I also did some commercial work, some civil rights work, some business litigation. I was appointed to the Denver District Court, where I am now. I've been there about 8 years, and I'm currently in a civil division where cases like the one you're going to try here today would be tried in Denver. So And I'm very excited to be here because I've heard a lot of great things about this tournament. So good luck to all of you.
Thank you. And then our last scoring panelist is Cyril Vidigar. Mr. Vidigar, go ahead.
Thank you, Your Honor. My name is Cyril Vidigar. I'm currently a municipal attorney with the city of Fort Collins. I actually was in this competition myself when I was in high school. I won't tell you what school I went to, but I've followed the program since I was in high school. I aspire to be a judge someday, but currently I do primarily transactional work with technology and intellectual property for the city of Fort Collins, as well as regulatory utility or regulated utilities work. I've been on the committee that has drafted the problem since 2005, maybe. So I've seen a lot of these competitions over the years, and I've had the pleasure to be a presiding judge at a few of the state tournaments as well. So I'm really looking forward to seeing how this goes this evening.
Fantastic. For our panelists, thank you all very much. I'll do a little background myself, but it's not nearly as important because although I'll be ruling, I will not be scoring any of you. But my name's John Madden. I'm the chair of the Mock Trial High School Committee, which means I rely on Amy Shreenan and Ashley Staub, who you have all known, to basically run everything and take care of that. I am a retired judge out of Denver. I was a district court judge for close to 15 years, and I now do private work in terms of mediations, but I also have coached high school mock trial, undergraduate mock trial for a couple of schools, and I'm presently one of the coaches for the trial team at DU Law School as well. With that, we won't go much further into that. We'll try to get things started, and so we can move on to this. What I'd like to do at this point for our scoring panelists is we've put rosters in the chat. So each of the participants has their name on their screen. You can use that certainly. But if you wanted to download a copy of their rosters, you can do that as well. What I want to do is remind everyone in terms of the teams at this point. The Colorado Bar Association may be either taking still photographs or using recordings of the competition from this round, that the team participation in the state tournament grants permission for the use of the photos by the Colorado Bar Association for promotional and other purposes. Most of the things we would talk about, we won't worry about because we don't have anyone in the gallery there watching outside of that. So I'm going to skip down to this. I do want to remind you that there are no recesses allowed, with the exception of those that are granted for health emergencies, but there are not recesses between the witness examinations, the beginning of closing arguments, and so on, as you all know. What I want to do at this point is just to check with our scoring panelists that if any of you think you have a reason that you might be biased in judging either team, and if you let me know if you recognize any participants or think you know someone or might have some concern. All right, all heads are shaking no, so we're in good shape with that. I do want to remind the teams if there's any disputes that arise out of the competition, they have to be reported in accordance with the competition rules. That means if we have an in-the-bar dispute, that has to be handled through the in-the-bar dispute process. I'm not expecting that with the professionalism scores I saw from both of these teams. But if it does come up, remember that you do have to follow those rules and procedures. Also for our teams, your compliance with the time requirements would be considered in your scoring your individual performances. In other words, if you run over with the timing, that's something that the scoring judges can take into consideration with their scores. And at this point then, what I'd like to do is if I could have each of the teams introduce yourselves, starting with your attorneys and witnesses, and let's begin with the plaintiff. If you could have entries of appearance and introduce yourselves to our scoring panelists.
Good evening, Your Honor, opposing counsel, and members of the jury. My name is Leah Dino, and today I will be conducting the direct examination of Dakota Weirs, the cross-examination of Skylar Weirs, and delivering the closing argument. At this time, may my co-counsel introduce themselves?
Yes, please.
Good evening. My name is Andrew Markle, and I will be conducting the direct examination of Carson Durst, the cross-examination of Blake Doncourt, as well as delivering the opening statement.
Good evening. My name is Braden Stewart, and I'll be conducting the direct examination of Dr. Casey Rogers and the cross-examination of Dr. Devin Williams. At this time, may the plaintiff witnesses please introduce themselves.
They may.
Good evening, Your Honor.
My name is Octavia Gomez, and I am Dakota Weirs.
Good evening, Your Honor. My name is Ella Damon, and I am Carson Durst.
Good evening, Your Honor. My name is Maisie
Rogich, and I am Dr. Casey Rogers.
Thank you all very much. And let's go to entries of appearances and introductions by the defense.
Good evening, Your Honor, opposing counsel, and members of the jury. My name is Lily Radowski, and today I will be delivering the opening statement on behalf of the defense, as well as conducting the direct examination of Blake Doncourt and the cross-examination of Carson Durst.
Thank you.
Good evening, Your Honor, opposing counsel, members of the jury. My name is Jordan Ryan, and today I'll be conducting the direct examination of Dr. Devin Williams and the cross-examination of Dakota Weirs.
Good evening, Your Honor, opposing counsel, and members of the jury. My name is Charlotte Combe, and today I will be conducting the direct examination of Skylar Weirs, as well as the cross-examination of Dr. Casey Rogers. I will also be delivering closing arguments on behalf of the defense. At this time, may our witnesses and timekeeper please introduce themselves?
Yes, please.
Good evening, Your Honor, members of the jury. My name is Olivia Longi, and today I am Blake Doncourt.
Good evening, Your Honor, members of the jury. My name is Harriet Falconetti, and today I am Skylar Weirs.
Good evening, Your Honor, members of the jury. My name is Milo Lamas, and today I am Dr. Devin Williams.
Good evening, Your Honor, and members of the jury. My name is Magdalena Bratic, and today I'll be keeping the time.
Thank you all very much. In that case, if I could have the team members please raise your right hands. And for our team members, do you promise that the presentation you're about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
I do.
I do.
Thank you. Also for our witnesses, if you'll raise your right hands, do you promise that the testimony you're about to give will faithfully and truthfully conform to your witness statements, and that you will not add material facts or opinions which are not contained in the case problem, and that you will follow the rules and procedures of the mock trial competition?
I do.
Thank you all very much. For our scoring panelists, if I could swear you in as well for the 5 of you, do you also promise to adjudicate the mock trial competition as fairly and objectively as possible in accordance with the facts, procedures, and rules of the mock trial competition?
I do.
Thank you all very much. In that case, we're ready to begin with the case. And so let me go ahead and call the case of Dakota Weirs versus Lush Fertilizer, Inc. We'll begin at this point with our opening statements. For our competitors, we'll have the scoring panelists leave their cameras active for this point. We'll turn them off during witness examinations. But we'll begin with the plaintiff's opening statement. Is the plaintiff ready to proceed?
Your Honor, the plaintiff has a few preliminary matters before we continue to opening statements.
I skipped that. My apologies. Absolutely. Let's get to housekeeping matters before we start opening statements. Ms. Dino, go ahead.
Your Honor, we ask that stipulated facts be entered into evidence and constructively read to the jury.
All right. We'll presume that these stipulations are accepted. You may certainly refer to them at any point during the trial, including your closing arguments. And I think they are in the materials for our panelists. That'll be accepted.
Secondly, we'd like to confirm with opposing counsel that all witnesses have physical exhibits and their witness statements in front of them.
And I'll verify that with the defense. Is that correct that your witnesses have access to their statements and materials?
Your Honor, pursuant to Tournament Rule 7.4, if our witnesses are in need of their affidavits or exhibits, we are prepared to constructively screen share them to them outside the eyes of the jury, instead of as opposed to having physical copies present with them. Yes.
And so I know for cross-examination, if they were asked about an exhibit or their statement for impeachment purposes, do they have copies available, or would the opposing counsel need to be able to screen share those for impeachment and so forth?
Your Honor, we ask that opposing counsel screen share affidavits or exhibits if they are going to be using them in cross-examination for our witnesses.
All right, Ms. Dino, anything further in terms of that then?
If the witnesses do not have access to their witness statements, our team can screen share the witness statements and exhibits for matters of impeachment. Going off of that, just for clarification, so exhibits will be screen shared prior to their entrance into evidence, but constructively hidden from the jury. Is that what I'm understanding?
That is correct. In other words, we'll allow you to show exhibits on the screen through screen share. Obviously, in a real trial, the jury would not see those because they can't see them until they're admitted. Our panelists will see that, but constructively, they will understand that as jurors, if they were deciding the verdict in the case, they wouldn't see those exhibits unless and until they're admitted. But for scoring purposes, they can see them, and constructively will say that the jury would not.
Yes, Your Honor. Thank you for the clarity. Next, if an objection on prior testimony is sustained, would you like us to move to strike that testimony or consider that testimony automatically stricken?
I think it'd be best at your, I'm sorry, what I'd do is if you believe the testimony should be stricken, if you'd ask that, then I'll make that determination. So in other words, we won't assume it's stricken unless and until you ask me to do so.
Yes, Your Honor. And then lastly, in closing arguments, we ask that all time remaining is reserved for rebuttal and that the jury is constructively given jury instructions before closings begin.
Both of those will be granted as well. We'll assume that, in other words, you don't have to request additional time for rebuttal on closing. And then the jury and the jury instructions will be constructively read to them before the closing arguments.
Thank you, Your Honor. Nothing further from the plaintiff.
Any housekeeping matters by the defense?
Yes, Your Honor, just a few things. Firstly, pursuant to Tournament Rule 7.4, we ask that during direct examinations and cross-examinations, witnesses be allowed to annotate exhibits using Zoom annotation features.
As long as it's one of the Zoom features compliant with Rule 7.4, unless there's an objection to that, that's perfectly fine. I think that rule specifically allows you to use, for instance, the whiteboard or the annotation features that are part of Zoom.
Yes, Your Honor. Next, we ask that if at any time the court cannot see or hear a witness testifying or lawyer presenting, that the court intervene immediately and that time be halted until the issue is resolved.
I will do my best, but that's a fair request, and as much as physically possible, it will be granted.
Yes, Your Honor. And lastly, while we understand no recesses are allowed between direct examinations or statements, we ask that a few seconds be given in between examinations so that the jurors have time to score and that we have time to readjust our cameras and microphones.
That will be granted as well, and that is certainly my plan, but I appreciate the reminder. Thank you.
Yes, Your Honor. The defense is ready to proceed.
All right, thank you very much. Ms. Dino, let me get back then. I think I was jumping the gun, but are you ready to move on to your opening statement?
My co-counsel, Andrew Merkel, will be delivering the opening statements, but he is ready. Yes, Your Honor.
All right, in that case, we'll turn this over to the plaintiff and you may proceed.
Good evening. My name is Andrew Markle. Along with my co-counsel, I represent the plaintiff, Dakota Weirs. Dakota Weirs has cancer. At just 20 years old, her life is essentially ruined. She should be in college working toward her dream of becoming a concert pianist, but instead, she's in a courtroom in Denver trying to get justice for what the Lush Fertilizer Company did to her. Ms. Weirs will tell you that at age 14, she started working for a landscaping company to make money for school. She worked with fertilizers, including one manufactured and sold by Lush, containing a chemical called Drufo. Dakota Weirs didn't know it at the time, but Drufo was dangerous, and her exposure to Drufo caused non-Hodgkin's lymphoma, a cancer in the lymph system. You will hear about the symptoms of non-Hodgkin's lymphoma. Ms. Weirs is in constant pain, she has no energy, and she can't play the piano. Piano was her greatest joy. She started playing when she was young alongside her beloved grandfather, and as she got older, her talent really emerged, and she even earned a scholarship to Juilliard, the most prestigious music school in the country. But then she got sick and she couldn't accept her scholarship. In fact, you will hear she's not able to do much of anything. She's depressed, she's anxious, she has lost all hope. Non-Hodgkin's lymphoma cannot be cured. So where does Lush Fertilizer fit in? Lush's greed is killing Dakota Weirs. The testimony will show that when it came time to test Drufo for safety, Lush decided to prioritize their profits instead of the lives of their users. You will hear from Carson Durst, a former employee of Lush. She will tell you Lush knew there is a connection between Drufo and cancer, and if they didn't know, they should have. There were red flags everywhere. Carson Durst's own research uncovered a study showing an increased risk of non-Hodgkin's lymphoma, especially in young developing animals. Other researchers at Lush raised concerns about cancer in humans, but Lush deliberately ignored the evidence. And as soon as Ms. Durst raised concerns about the safety of Drufo, she was marginalized and given poor performance reviews. You will also hear from Dr. Casey Rogers. She performed her own study on Drufo and found that workers with prolonged exposure were 10 times more likely to be diagnosed with cancer. Lush's witnesses will suggest Lush didn't really know Drufo was dangerous. Blake Doncourt, Lush's CEO, will testify the studies weren't conclusive. Devin Williams will say the increased risk isn't statistically significant. Dakota Weirs' twin Skylar Weirs will also testify. Although Skylar Weirs purports to be an expert in Drufo, she is not. She's a part-time magazine writer, not a scientist. She will say she doesn't know of any study proving a link between Drufo and cancer with certainty. Listen carefully to this testimony because you will hear a lot of words like certainty and inconclusive, but the court will instruct you at the end of this case that absolute certainty is not the standard. All the plaintiff must show is that Lush knew or should have known its product was dangerous and that it did not use reasonable care to warn its users. Lush didn't use reasonable care. All Lush had to do was put a label on its fertilizer saying, "Warning, use of this product may cause cancer. Follow precautions." A simple, reasonable step to keep users safe. Lush didn't do that. We will show you the label that Lush did use. It has generic recommendations about wearing a mask and long sleeve clothing. There is nothing on that label that would warn users about the actual risks they were taking. There was another way Lush could have kept its users safe. You will hear about a process called baking, which eliminates the risks from Drufo. Lush decided against baking Drufo because it cost too much money, and Lush decided to pay off its investors instead. Lush Fertilizer's greed kills people. Plaintiff must prove its claims by a preponderance of the evidence, which simply means more likely true than not. After hearing all the evidence, there will be only one reasonable conclusion. Lush was negligent by failing to properly warn its users of the dangers of Drufo. Greed kills. We ask that you find in favor of Ms. Weirs and award her the amount that will compensate her for the damages that Lush has caused. Thank you.
Mr. Markle, thank you very much. In terms of the defense opening, is the defense ready to proceed?
Yes, Your Honor.
Mr. Rudowski, when you're ready, you may proceed.
Someone to blame. Mr. Markle just told you a story. A story of a tragedy. A story with a villain. A company whose greed killed. But today, I'm going to introduce you to Blake Doncourt, the CEO of Lush. Ms. Doncourt has dedicated her entire life to protecting the environment and creating a fertilizer that is safe for people to use. She's put this above everything else. There is no villain in today's story. Just a desperate family looking for someone to blame. In order to understand what's happening today, we need to go back to the beginning, when Lush Fertilizer was first created. It's early 2000. Blake Doncourt sees the amount of damage that fertilizer is doing to the environment and decides to do something about it. She creates her own alternative, a better one that is safer. Before putting her product on the market, Ms. Doncourt conducts study after study after study to make sure that her fertilizer was safe. And you'll hear that it was. Several years later, Dakota Weirs begins working at Havens Landscaping. Now you're going to hear that Havens used Lush Fertilizer, but also that they used multiple other ones. Ms. Weir's job was to spread the fertilizer, to work with chemicals day in and day out. But her bosses at Havens never told her what these fertilizers were, how many there were, or what was in any of these chemicals that she used every single day. Dakota Weirs was 14 years old. Havens Landscaping sent a 14-year-old girl out every single day to work with chemicals. They told her that she needed to wear a mask, needed to wear protective clothing, needed to protect herself. But they never followed through. So you'll hear that she didn't. Several years later, Ms. Weirs is diagnosed with non-Hodgkin lymphoma. Her family is devastated. They scramble to find a reason, any reason why their daughter is so sick. They're desperate to find someone, anyone, to blame for what happened to Dakota. They find a study. The study was done by Dr. Casey Rogers. This study said that Lush fertilizer could cause cancer. Never mind, the study was never published. Never mind, the study was never peer-reviewed. Never mind, the data collection methods were flawed. They had found someone to blame. Today, the plaintiff is suing Lush Fertilizer for negligence. The burden of proof is on them. That means that it is their job to prove to you today, by a preponderance of the evidence, that Lush Fertilizer knew or should have known that their product could cause cancer, and that it was Lush and not something else that caused Dakota Weirs to develop non-Hodgkin lymphoma. They will not be able to prove this to you today. Today, we, the defense, are going to ask you to keep in mind 3 questions throughout today's trial. 1, can you trust Casey Rogers' study? 2, was it something else other than Drufo that caused Dakota Weirs cancer? 3, did Ms. Weirs protect herself? At the end of today's trial, my co-counsel, Charlotte Combe, will stand before you and ask you these same questions. She will ask you for a verdict of not liable, because the plaintiff is looking for someone, anyone, to blame. Thank you.
Thank you very much, Mr. Dusky. What we'll do then is, for our scoring panelists, I'll allow you, you can go ahead and turn off your cameras for bandwidth issues. Anyone who's not as familiar with Zoom, if you'd like, you also have the option in the upper right-hand corner. You can go ahead and select the speaker view so that that one person speaking will pop up and take up more screen space. That's entirely up to the panelists if they'd like to do that. But with that, we'll go ahead and move on to the next section of the trial, which will be the presentation of the evidence in the case, beginning with the plaintiff's case in chief. Is the plaintiff ready to call their first witness?
Yes, Your Honor. The plaintiff calls Dakota Weirs.
Thank you very much. Ms. Weirs, at this point, you've already been constructively sworn, so I will turn this over to counsel. Ms. Dino, when you're ready, you may inquire.
Good evening, Ms. Weirs. Please state your name and spell your last for the record.
My name is Dakota Weirs, W-E-I-R-S.
How old are you, Ms. Weirs?
I'm 20 years old.
And you are the plaintiff in this case, correct?
Yes,
I am.
Your Honor, leading.
Right. Any response?
Yes, Your Honor, this is a foundational question. Leading questions are valid for foundational and not basic questions. They're legal.
Right. In discretion under Rule 611, I'll go ahead and allow it, since we're only getting to the preliminary matters. I'll allow that, but past that, I would probably sustain the objection. Objection's overruled at this point. You may proceed.
Ms. Weirs, can you briefly explain to the jury why you are suing Lush Fertilizer?
I'm suing Lush Fertilizer because I have cancer, and it's called non-Hodgkin lymphoma, and it's a type of blood cancer. And I believe that Lush Fertilizer is liable for my cancer because of a chemical called Drufo that's in their product.
Now, Ms. Weirs, let's take a step back and talk about your exposure to Lush fertilizer. How are you exposed to the fertilizer?
Well, I worked at a local landscaping company for about 4 years as a landscaping technician.
And as a landscaping technician, what did your job entail?
Well, at Havens, my job was mainly to spread the seeds and the fertilizers, and I ended up using the fertilizer both indoors and outdoors.
And when you were using Lush fertilizer, did you ever look at the label?
Yes, I did.
And on that label, did you see a warning about the long-term effects of the fertilizer?
Objection, Your Honor. Best evidence.
And your response is to best evidence.
Yes, Your Honor, there are exhibits referring back to the label of Lush fertilizer. This is a foundational question clarifying that Ms. Weirs has seen the label and the preliminary contents of that. We will move to enter the exhibit later on.
Right. And at this point, were you, absolutely, but before we do, were you asking to have her disclose the contents of the label, or just confirming at this point that she had seen it?
Just that she had seen it and she had not seen a specific warning about long-term use, those two things.
All right. Ms. Rain, is it Ms. Rain or Ms. Ryan?
Ms. Ryan, Your Honor.
Ms. Ryan, my apologies. Go ahead, your response.
Your Honor, this question calls for this witness to talk about what specifically is or is not present within a document. Therefore, the best evidence would be that exhibit in this case.
All right. At this point, I've got no problem with asking if she had seen it as to what was not on that at this point or its contents. I'll sustain it at that point unless and until we have the exhibit admitted. So it's partially sustained as to the contents or what was not present, but I would let you ask the questions about if she's familiar with it or foundational. Objections partially sustained, partially overruled. You may continue.
So Ms. Weirs, when did you first become ill?
I became sick right before I was about to go to college, and I had no idea what was happening to me.
What sort of symptoms were you having?
Well, I was having a lot of weight loss. I was in and out of the hospital. I have swollen lymph nodes, and I always get so achy now. It's so hard to sit down for long periods of time. And most of all, I'm just so tired.
Ms. Weirs, how has the non-Hodgkin's lymphoma affected your life?
How hasn't it affected my life? Everything I've ever known has turned upside down. I can't work. I can't go to school anymore. I can't go to Juilliard, my dream school. All of that is ruined. And even if I do go into remission, my life will never be the same.
You were planning on going to Juilliard?
Yes, I got a scholarship there. The big New York City, is my dream.
Ms. Weirs, are you hopeful you're going to get better?
My doctors are hopeful, I guess, but they have to tell me that. But I don't see how I can have any hope. I mean, my doctors haven't spent the past 2 years in a living hell. And so, no, I don't have any hope of getting better because I'm not getting any better.
Now, at the beginning of this questioning, you mentioned Drufo. When did you first become concerned that Drufo was related to your diagnosis?
Well, I was sitting on the couch watching TV, like I always do these days, and I saw a story about how Drufo could potentially cause cancer.
Objection, Your Honor. Hearsay.
Your response is to hearsay.
Yes, Your Honor, this is not hearsay under Rule 801C because although this is an out-of-court statement that is being used for the truth of the matter asserted, it's not being used for the truth of the matter asserted. It's being used for the effect on the listener. The truth of what was on the news segment is irrelevant, and the purpose of this testimony is to illustrate what led Ms. Weirs to continue investigating Drufo and call her boss at Haven Landscaping.
May I respond, Your Honor?
You may.
Your Honor, if opposing counsel is using this testimony for that purpose, I would then like to change my objection to more prejudicial than probative.
Right. And tell me a little bit more. I think I understand the basis of the 403 objection.
Yes, Your Honor. If this is being used for the effect on the listener, there's an unfair prejudicial value towards Lush fertilizer by eliciting the testimony that it's possible that Drufo causes cancer. It's already been established that this witness believes that Drufo caused her cancer. Showing the steps of how she got there in this specific testimony has an unfair prejudice.
And Ms. Dino, your response.
Yes, Your Honor. Under Rule 403, a prejudice that encourages the jury to make a decision on an improper basis is invalid. There is no information that just the knowledge of Ms. Weir's watching a news segment could bias the jury to make a decision on the basis of emotion or any other invalid claim. We're just using this to prove the steps that Ms. Weir's took to calling her boss and receiving a picture of the label to make sure the jury knows she wasn't jumping to conclusions.
As an offer of proof, what do you believe that the statement was on the news station that she'll be testifying to?
She has already completed that she just learned that Drufo and Lush fertilizer possibly caused non-Hodgkin's lymphoma. That's it.
All right. And Ms. Ryan, go ahead. I'll let you reply.
Yes, Your Honor. In this case, there's an unfair prejudice presented to Lush fertilizer because of the words heard on the news cycle. As well, the probative value in this is substantially outweighed by that because we've already heard testimony that this witness believes Drufo is responsible. If opposing counsel would like to lay other foundation as to how this witness knows about the label, that would be acceptable, but the probative value in this case is outweighed by the prejudicial one.
Under Rule 403, I'm going to find that the reasons she took the steps or the reasons that she acted have some relevance, but it's relatively minor. I am going to find that the statement or belief that Drufo may cause cancer is a risk of being used for an improper purpose and has virtually no relevance from the hearsay perspective of that. So I will partially sustain under 403. The fact that she heard a news broadcast and she followed up on that is perfectly acceptable. That can stand. What the news broadcast said, I'll sustain on hearsay grounds and also under 403 and let you proceed. So Ms. Dino, with that modification, you may ask your next question, proceed.
Ms. Weirs, did you ever see a picture of the label of Lush fertilizer?
Yes. After I was watching TV, I contacted my boss immediately to verify that I had used Lush fertilizer while I had worked for him.
And did your boss send you the label?
Yes, he did.
And that was the same label from when you worked at Haven Landscaping?
Yes, it was.
Can you please turn your attention to Exhibit 1? What is this, Ms. Weirs?
This is the label that my boss sent me. It's an exact copy of the label that I had worked with at at Havens.
Is this a true and accurate representation of the Lush fertilizer label that you saw when you worked at Haven Landscaping?
Yes.
Your Honor, we move to enter Exhibit 1 into evidence.
Is there any objection to Exhibit 1?
No objection to Exhibit 1, Your Honor.
Exhibit 1 is admitted.
Ms. Weirs, can you read the ingredients on this label?
The active ingredients are Drufo, nitrogen, phosphorus, potassium, calcium, iron, and other ingredients.
And on this label, is there anything about the dangers of long-term use?
No, there's nothing about the dangers of long-term use, and that's because Lush doesn't care. There's not
Objection,
even the
Your
word.
Honor. Speculation.
Any response to speculation?
The witness is testifying to her present sense impression. The objection goes to wait.
All right. I'm going to find she's speculating as to Lush's motivation. So I'll sustain as to speculation as to why Lush did something or what Lush believes. I'll let you ask a different question.
Ms. Weirs, does the label say anything about cancer?
No, it doesn't.
Thank you. That'll be all for Exhibit 1. Now, you previously mentioned that you started playing piano because of your grandfather. What's your relationship like with your other family members?
Well, I've lost so much to this cancer. I didn't think I'd lose my twin sister too, but our relationship is pretty tumultuous right now, and she's even testifying against me today in court.
What impact has her testimony or her testifying today in court had on your relationship?
I mean, it's heartbreaking to know that my sister won't be there to hold my hand in the last few painful years of my life.
Are you aware of what your sister does for a living?
Skylar calls herself a journalist, but she's also a part-time server at a restaurant.
And as a journalist, do you know what kind of articles she writes?
Skylar writes on an assortment of articles ranging from UFOs to the flat earth theory and even anti-vax culture.
Are you aware if Skylar Weirs has any financial troubles?
I'm aware that Skylar has extensive gambling debts.
And is your father paying for your treatment?
Yes, he is, and I will always be so grateful for what he sacrificed for me.
Has the fact that your dad is paying for your medical debts caused problems within the family?
Yeah, Skylar acts like she resents me because my father has been paying for my medical bills and not paying towards her gambling debts. And she's led me to believe that my cancer is my fault and that I'm a burden and I'm draining my father of all his money.
Objection, Your Honor, lacks foundation.
Any response?
Yes, Your Honor. We have clarified that there's a tumultuous relationship between Skylar and Dakota Weirs, that Dakota Weirs' father is paying for her treatment and not paying for Skylar's medical bills. Those are all of the variables that are going into the statements and the present sense impression that Ms. Weirs is testifying to right now.
Your reply.
Your Honor, this lacks foundation as to exactly what this witness observed that made her think that. I understand she can talk about the facts of who their father was giving money to, but as to her opinion on that relationship, the foundation is to be laid for something that she specifically observed as to why she thinks that, or else it's speculation on her behalf.
I think we're a little light in terms of the basis for personal knowledge that has to be established under Rule 602 before the witness can testify to that. I'm not saying it's not there, but I'll sustain as to the lack of foundation. I'd let you lay additional foundation or move to a different area. Ms. Dino, when you're ready, I'll let you resume.
Your Honor, move to strike that testimony.
In that case, I would instruct the jury to disregard the last answer, and Ms. Dino, you can proceed.
Ms. Weirs, is there anything that your sister has said or done that has made you feel issues within the family dynamic?
Yes, based on my own personal observation, Skylar seems to resent me for being sick because I know that my father's paying for my medical bills and not her debts, and she seems to resent me for that.
Ms. Weirs, what damages are you seeking from Lush Fertilizer?
I'm not asking Lush to pay for my medical bills or for any lost job opportunities I may have had in the future, but Lush's greed has killed my hopes, my dreams.
Objection, Your Honor. Speculation.
Any response?
The witness was testifying to her feelings, her emotions, not actual fact. She's not speculating to any sort of statement or emotion of another party.
Ms. Ryan, your reply.
Your Honor, this witness is speculating that Lush Fertilizer's greed is what caused problems in her life. That's speculation that she doesn't have personal knowledge of.
I'm going to overrule this to speculation. I'll allow you to cross in that area in terms of the basis of knowledge or the opinion aspect of that. But I do think it's not a speculative position in terms of the effect or impact on her. So objections overruled. The answer will stand. I'll let you continue.
Ms. Weirs, would you like to continue your answer or me to restate the question?
I can continue. I was saying Lush's greed has killed my dreams, my hopes, my dignity. And even in this trial today, Lush is villainizing me as a bratty child who only wants to blame someone. But I know that my cancer is not my fault. And Lush is trying to frame me for their negligence, it seems.
Objection, Your Honor. Speculation to that.
Any response?
Again, Your Honor, she's testifying to her emotion. I'll ask for clarity on what statement Ms. Weirs was speculating on.
I think I heard that Lush was trying to frame her. What would be the response that was not speculation?
This is Ms. Weirs' present sense impression. As she's not an expert or a member of Lush Fertilizer, the jury can address that and wait.
In this particular one, unlike the last one, I think this one goes a little further. I am going to sustain as to the last statement in terms of projecting their motives or deciding what they are attempting or trying to do. The jury can certainly decide that, and that can be argued at the end, but objection sustained.
Ms. Weirs, is there an amount of damages you're asking for?
Yes, I am suing Lush Fertilizer for $2,615,553 in emotional damages.
Why that amount?
Well, that's the amount that Lush Fertilizer pocketed instead of baking
Objection,
Truffaut.
Your Honor. Lacks foundation.
Any response?
Your Honor, there will be testimony on that exact amount, and we expect Mr. Duncourt to testify, or if the court would prefer, I can give an offer of proof.
We can start with the offer of proof, but go ahead.
So Blake Duncourt, who's the CEO of Lush Fertilizer, will testify about analysis of the cost of baking Drufo, which is proven to decrease the carcinogenity of it. That testimony and an exhibit entered during that testimony will prove that from 2004 to 2014, if Lush Fertilizer had baked the Drufo, the estimated lost revenue is $2,615,553.
Response to that, Your Honor?
You may.
Your Honor, I appreciate that this witness can talk about how much she wants in damages from Lush Fertilizer, but she personally doesn't have the personal knowledge to be talking about that. As opposing counsel said, they'll be talking about it later with witnesses who do have personal knowledge. I believe that's the proper time, not through this witness.
Under Rule 602, I will sustain the objection. Certainly the testimony that is the amount she's seeking can stand. Verification as to whether or not that was a profit will have to come through a different witness, and then certainly the argument about that can be made later. But objection sustained under Rule 602 as to what that amount represents.
Finally, Ms. Weirs, are you just trying to blame anybody for your cancer?
No, I'm not trying to blame anybody.
Thank you, Ms. Weirs. No further questions.
Any cross-examination?
Yes, Your Honor. Would you like me to wait a few moments for the jurors?
My hope is to definitely wait after this particular witness, give them a short break, but hopefully my talk at this point has given them a moment to collect their thoughts, and I'll let you proceed now.
Thank you so much, Your Honor. Ms. Weirs, I'm really sorry to hear about your diagnosis, and if you need to stop at any point, just let me know. We can go ahead and pause the time, all right?
Okay.
Ms. Weirs, it's your belief that Drufo caused your non-Hodgkin lymphoma, isn't it?
Yes.
To be clear, you're not a medical doctor.
No, I'm not a doctor.
You're not a scientist.
No, I'm not a scientist.
You're not an expert on the science behind non-Hodgkin lymphoma.
No, as I said before, I'm no scientist.
And you're not an expert on the science behind fertilizers either, are you?
No, no.
Ms. Weirs, I want to talk to you a little bit about your time at Haven Landscaping. You used to work there, correct?
Yes, I worked as a landscaping technician there over the summer times for about 4 years.
For those about 4 years, you worked to spread seeds and fertilizers, correct?
Yes, I did.
You spread many different types of fertilizers, didn't you?
Well, I did handle a variety of fertilizers. Some I was only allowed to use indoors or outdoors. It really depended on the fertilizer.
So you did use many different types, Ms. Weirs.
I used a variety of fertilizers, including Lush Fertilizer.
Ms. Weirs, you can't name every single fertilizer you used over about 4 years of working, can you?
Oh, that's not in my witness statement, but I would be happy to answer that.
Ms. Weirs, you didn't put that in your witness statement, correct?
No, I didn't.
Ms. Weirs, you don't have a list of ingredients for what was in all of those fertilizers, do you?
Again, that's not in my witness statement.
So Ms. Weirs, you didn't put a list of ingredients of those other things in your witness statement, yes?
No, I didn't.
Ms. Weirs, you sometimes worked outside when you spread fertilizers at soccer fields, correct?
Yes, soccer fields, houses of worship, a bunch of different places.
You'd agree with me that you also sometimes spread fertilizers indoors at office parks and malls?
Yes.
Ms. Weirs, you're aware that many of the fertilizers you used had warning labels on them, aren't you?
Yes, some of them did have warnings on them.
You're aware that some of those warnings said the product should only be used outdoors.
Objection, Your Honor.
Go ahead.
This is hearsay.
Thank you. Any response?
Your Honor, this is going to the effect on the listener in this case to show what she did, even though she was aware of what these labels said. I'm not using them for the truth of the matter that any of those other fertilizers were only supposed to be used outdoors.
All right. Tell me a little bit more about that. What is it you believe, how this goes to the effect on the witness or notice in terms of that?
Your Honor, this witness testified that she's aware that there were warning labels on many of those packagings. I'm going to ask her questions and will elicit the testimony that she used products indoors, knowing that she was not supposed to.
All right. Ms. Dino, your response.
Yes, Your Honor, this is being used for the truth of the matter asserted, as opposing counsel just stated what the warnings said. They're trying to use it to prove that Dakota Weirs ignored those warnings, and because those warnings stated not to be used indoors, she ignored that, but they're still using it to prove that those warnings talked about indoor versus outdoor. That's being used for the truth of the matter asserted under Rule 801.
All right. It sounds like they're a direction or a command. In other words, not an assertion that's true or false. It's do not use indoors. But in any event, I do agree that it sounds like it's being used to show that information was given to the witness and she acted in a particular way, regardless of whether it actually was true or false. And so I'll overrule as to hearsay and let you proceed.
Ms. Weirs, you're aware that those labels said you shouldn't use their products indoors, yes?
Well, some of them instructed me to either only use the product outdoors, or it said that I could use them in both places. Yes.
Ms. Weirs, you'd agree with me, you sometimes used those products indoors, didn't you?
Well,
Your Honor.
Go ahead.
I believe the purpose of this testimony is to prove that Dakota Weirs applied fertilizers indoors when labels warned against it, proving a character trait of laziness or ignoring recommendations. And I think they're using this testimony to prove that she acted in accordance with that trait at a future time, which is invalid under Rule 404.
Your response.
Your Honor, I'm not using this to show that on one occasion Dakota Weirs ignored a label and that she did so on another occasion. I'm using this testimony to show occasions in which she was exposed to other fertilizers, like the ones she used indoors, which is part of the defense's theory in this case.
Let me go back to then our hearsay issue that you weren't using it for the truth. What's the basis to say that she shouldn't have used it indoors or it was dangerous to do so, other than the truth of those statements on the labels then?
Your Honor, this goes again to, I apologize. This goes again to showing that Dakota Weirs was using other products in many different ways and in many different capacities, including her use indoors.
And then any final reply, Ms. Dino?
Yes, Your Honor. The two claims are contradictory. If it's not being used for the truth of the matter asserted, and it's being used to prove that Dakota had one reaction, that means it's improper character evidence as she's acting in accordance with that action. If it is being used for the truth of the matter asserted to prove that these products were dangerous and had warnings, then that is hearsay.
Your Honor, a final response.
You may.
I might also add that this under Rule 404B would qualify potentially as intent of the witness to go against those warnings, and therefore is an exception to any character evidence.
I'm going to disagree with that particular argument because I don't think intent is one of the elements that needs to be proven. It would simply be backdooring it for a different purpose in terms of that. I don't think under the circumstances, since the witness has testified how she used it, the label doesn't say that there's a warning. I don't think it'd be used for a character purpose of showing that she has a tendency to act contrary to the labels or is lazy in that regard. It is closer on hearsay, but I don't think it quite crosses that line still. So perhaps in a real trial, I might sustain one of those objections. In this case, for mock trial purposes, it's close enough to the line. I'm going to overrule the objections. You may proceed.
So Ms. Weirs, you sometimes used those products indoors, didn't you?
Occasionally, but for the most part, I would adhere to those rules.
Ms. Bartich, if we could get Exhibit 1 back on the screen. You're familiar with this exhibit, aren't you, Ms. Weirs?
Yes, this is the label that my boss sent me.
If you go ahead and look over towards the right part of the screen with me as I read aloud, under user safety recommendations, it says, as with any spray fertilizer, utilize protective clothing that covers all exposed skin, doesn't it?
Yes, but yes, it does.
Ms. Weirs, to be clear, you didn't wear long sleeves while you were working, did you?
No, I didn't wear long sleeves.
You didn't wear long pants?
No, I didn't wear long pants.
Instead, you chose to wear shorts and a t-shirt. Isn't that true?
Well, for Lush fertilizer, the only caution is that it causes eye irritation, and long sleeves and long pants don't cover your skin, or don't cover your eyes. Sorry.
Ms. Weirs, that wasn't my question. I'm simply asking that you wore shorts and a t-shirt, and that's correct, isn't it?
I did wear shorts and a t-shirt, as did my other coworkers.
Exactly. Other people at Haven Landscaping did that too.
Yes, my adult coworkers, and I followed their example because I looked up to them, and I had no idea what I was exposing myself to.
Exactly, Ms. Weirs. Haven Landscaping didn't force you to wear that clothing.
No, the wearing protective equipment wasn't always enforced at Havens, but Lush also failed to create an adequate label.
Ms. Weirs, you've gotten just a little bit ahead of me, but if you'll go ahead and look back at Exhibit 1, it also says use of a respirator or N95 mask recommended, doesn't it?
Yes, but I only worked in the summer times, and with a few people who with the few people that did handle the fertilizers with me. So I and my coworkers didn't wear an N95 mask. Personally, I didn't, because a mask doesn't cover your eyes, but I can't speak for any of my other coworkers that worked in the other seasons.
So Ms. Weirs, you didn't wear that N95 mask?
No, I didn't, because an N95 mask doesn't cover your eyes.
Ms. Weirs, you didn't follow the recommendations listed on that packaging, yes?
No, because none of the personal protective equipment covered your eyes, and that's the only warning that Lush fertilizer even has, a caution even. There's no warnings on this label. The word warning isn't even on this label. I bet Clorox has more details in warnings than the label.
I'm simply asking it that you didn't follow the recommendations listed that I just read aloud, and that's true, isn't it?
No, I didn't.
Thank you, Your Honor. I have nothing further.
Was there any redirect examination?
Briefly, Your Honor. Ms. Weirs, why didn't you wear long sleeves when working at Haven Landscaping?
Didn't wear long sleeves because the only thing that Lush fertilizer ever warned against was eye irritation, and my other adult coworkers also weren't wearing any protective equipment, and I thought that it was safe, but I was wrong.
And is that the same reason you didn't wear a mask or shorts?
Yes.
Would you say that you and your adult coworkers were acting reasonably?
I would say so. I mean, Lush fertilizer only warned about eye irritation. I mean, onions cause eye irritation, and onions are pretty harmless. So we thought we were being safe.
Thank you, Ms. Weirs. No further questions.
May this witness step down?
Yes, Your Honor.
All right. We'll go ahead and give the scoring panelists a moment to register scores. And if I hadn't said this for all of our participants, we haven't been raising it, but certainly my presumption at this point is that all discussions in terms of evidentiary rulings are taking place constructively at a sidebar, so we wouldn't have those discussions in front of the jury. But with that, we'll go ahead and let the plaintiff call their next witness.
Plaintiff calls Carson Durst.
Do we have our witness for Carson Durst?
Yes, Your Honor.
Oh, there we are. Thank you. Mr. Durst, thank you very much. And when you're ready then, Mr. Markle, you may inquire.
Good evening, Ms. Durst. Can you please state your first name and spell your last for the court?
My name is Carson Durst, D-U-R-S-T.
And what is your occupation?
Well, I'm the lead product developer for Terra's Greenery.
What education have you received?
I got my chemical engineering degree from Arizona State University.
Are you familiar with the defendant Lush Fertilizer?
I am. I used to work for the company.
When did you begin working for Lush?
Back in June 2003.
Do you know who founded Lush?
I do, Blake Doncourt, Miss Environmental. Hey, I'm all about saving the environment, but if it's at the cost of the people, that's where I draw the line, and that's why I'm here testifying today.
Do you know the Doncourt family personally?
I do. For a time, they were like the family I never had. Blake's son, Charlie, and I were best friends growing up. They drove me to every soccer game. I was always at their house for Sunday night dinners. But just like that, Blake kind of stabbed me in the back and didn't listen to me when I had serious reservations going on about his company.
And how did you first start working with Lush?
Well, an internship opportunity opened up, and I was brought to the attention by this through Charlie, and I applied and I was luckily hired.
What year was this?
2003.
Were you ever promoted after getting this internship?
I was 3 months after working.
And what was your new title?
I was now a product development engineer.
All right, Ms. Durst, what is Drufo?
Well, Drufo is a bonding agent in many of Lush's fertilizers. It helps keep fertilizer intact and preserved.
Do you know when this chemical was first introduced into the fertilizer market?
I do. I believe that it began its testing stages in 2003, but was introduced in the market in 2001.
Do you know whether Lush performed any in-house studies on that chemical?
Yes, several in-house studies were performed, 2 in fact, and this was a large part of my job.
And were these also a regular practice at Lush?
Absolutely.
Did you keep records of your findings?
I did. Every researcher puts all their analysis into a lab notebook, and this lab notebook is compiled into, well, all of the researchers' lab notebook is compiled into a single report that goes to upper management.
Now, what were you specifically tasked with doing in this research?
Well, I was specifically tasked with researching one chemical compound found in Drufo.
Did you find any studies discussing the safety of the chemical?
You know, I did. I found an English study, and this was studying whether Drufo was carcinogenic in rats.
And after you found this, did you put it in your notebook?
Oh yeah, I thought it very important.
Will you please refer to Exhibit 3 in front of you?
Yes.
What is Exhibit 3?
Well, this is a copy of the English study that I put directly into my lab notebook.
Is this a true and accurate copy of the English study you documented in your notebook?
Yes, it is.
Your Honor, plaintiff offers Exhibit 3.
Is there any objection to Exhibit 3?
Yes, Your Honor, to hearsay.
What's your responses to hearsay?
Yes, Your Honor, this is not hearsay because it is not being used for the truth of the matter asserted. This study was relied on by her and was made available to the executive at Lush. Any specific statement in the study, being true or not, is not material. It's only being used to show that the information was provided, whether or not it's true. And for the extent that it is hearsay, it falls under the business records exception of 803(6)(c). As this is a record of an act, event, or condition, it falls under this rule because making a record of studies at Lush Fertilizer by the research and development team was a regular practice. She is qualified to testify to this, and there's no evidence of lack of trustworthiness.
Response, Your Honor.
You may respond.
To Mr. Markle's first point that it's not being used for the truth of the matter, I would disagree with that. This study directly says that Drufo is an ingredient in Drufo is carcinogenic in rats. That is a key element of the plaintiff's burden and absolutely is material. As to the business records exception, this study was not conducted by Lush specifically. As the witness just testified, it was conducted in England. Even if it might be regular business practice to record these studies, it was not conducted by Lush itself.
And Mr. Markle, your reply.
Yes, Your Honor. This is not being used for the truth of the matter asserted, as we are using these statements to show that these specific statements were provided to Lush's management, whether or not they're true. Ms. Durst found this study, and she relied on the contents of this study, but we are only using this study to show that these statements were provided to management, whether or not they're true.
Let me ask, if they were untrue, what relevance would it have? In other words, if they're false statements, it seems that they're not admissible. Why would this not be being admitted for the truth of the matter asserted?
Your Honor, even if it's not true, these statements were still provided to management, which which goes to the second study that Lush Management performed on Drufo based on these concerns, whether or not they were true, which is why the second study was performed.
Help me a little bit in terms of that. When we talk about the second study, specifically, what do you mean? I think I know, but what do you mean?
Yes, Your Honor, Lush Fertilizer, there will be further evidence down the road, especially with Exhibit 4, where another study was specifically studying the effects of Drufo on humans, whereas this one is specifically on rats. And the carcinogenity in rats in this one, whether or not that's true, led on to the study studying effects on humans.
And I don't want to drag this out too far, and I'll try to move on quickly, but if it turned out that we're saying we're not using it for the truth, what are you using it for other than to say, well, we told management? Why is that relevant?
This is the Lush Management knew of these statements, and it's relevant because regardless of the contents, this document was provided to management, and they were put on notice of the carcinogenic qualities, whether or not this document is true, which is why this is relevant to the case.
And were you moving to admit Exhibit 3 at this point, or how I apologize, I lost track of how we got to the objection.
Yes, Your Honor, we're moving to admit.
At this point, I am going to sustain the objection as to hearsay, given the arguments. Exhibit 3 is declined at this point. You did mention the business records. I don't think we've met the requirements for 803.6 for business records at this point. And I do think the value in the details in the exhibit itself go to the require that it be true. So I will sustain the objection.
All right, Ms. Durst. Through your research and the studies that you documented in your notebook, what conclusions did it conclude about nitrogen phosphorus carbonate?
Well, through studying this specific chemical compound in Drufo, I learned that there was in fact a link between Drufo being
Objection, Your Honor, facts not in evidence.
Tell me more the basis of the facts not in evidence. So it seems like she's eliciting facts. Why would those not be facts and evidence?
Yes, Your Honor, these facts are specifically held within Exhibit 3, and there's a lack of foundation as to what these conclusions would be if the exhibit is not entered.
Right. Mr. Markle, your response.
Yes, Your Honor, we are not referencing any specific exhibit with this line of questioning. I am specifically asking about her research lab notebook that she kept as an employee of Lush Fertilizer. And as she was an employee of Lush Fertilizer and kept this notebook, she has personal knowledge of what she included in this notebook, and that is what I am asking about at the moment.
Let me ask still at this point, why is the contents of the notebook relevant in the case?
The contents of the notebook is relevant to this case because the further testimony will show that this notebook was provided to upper management, and they were aware that Ms. Durst found these studies pointing to carcinogenic effects of Drufo.
As an offer of proof, what did they do in response to that?
Your Honor, it is our position as the plaintiffs that that Lush Fertilizer received these notebooks, knew of the carcinogenic effects, and then did nothing about it.
I want to go back to, excuse me, to Ms. Radowski. If this is a person acting on behalf of Lush, and this would be knowledge or information known by Lush, as opposed to just simply trying to prove the truth of the statement, why isn't this basically admissible in terms of what Lush was aware of and what they thought or they believed at the time?
Yes, Your Honor. My objection would be to lack of foundation. As Ms. Durst was about to testify about the contents of that notebook, there's no foundation as to how she got those conclusions, how she recorded it, how she came to any of the data cited in the notebook at all.
It is a close call again, but I think the original objection was that to facts not in evidence, and she was testifying as to what was conveyed. She's testified, and there's been an offer that this was passed on to upper management. Under all those circumstances, I'm going to overrule that current objection, let the answer stand, and let you continue with the question.
Yes, Your Honor. Ms. Durst, so can you repeat your answer? So what conclusions did the study conclude about nitrogen phosphorus carbonate?
Well, my analysis concluded when researching this one chemical compound found in Drufo was that it in fact did pose carcinogenic threats as shown in rats. And so I put it in my notebook because I thought it would be very important for upper management to see.
Were there any occupations that were more prone to exposure to this chemical?
Well, yes, any occupation that works hands-on with this chemical would be.
Objection, Your Honor, lack of foundation.
Any response?
Yes, Your Honor. Ms. Durst is a researcher on Drufo and its carcinogenic effects at Lush Fertilizer, and therefore she has the proper knowledge, and we have laid the proper foundation that as an employee of Lush, she does have the knowledge to know what occupations are more prone to exposure to this chemical.
All right. At this point, I think we've strayed into a 702 opinion that requires specialized knowledge as opposed to simply her perceptions. I'm going to sustain the objection as to an improper expert opinion and let you proceed.
Ms. Durst, do you know whether anyone else at Lush reviewed your notebook?
Well, I don't really know what happens in the upper flagpole of management, but I would truly hope that if, because this study and my research were so important, that Lush would look at this and they would know.
And who is your supervisor that generally reviewed your notebook?
Jerry Langley.
Now, what happened after all the notebooks had been reviewed?
Well, after all the notebooks had been reviewed, we got an email about a second in-house study that was going to be conducted.
And was this another study performed by Lush on the safety of Drufo?
Yes, it was studying whether Drufo was carcinogenic in humans.
Now, can you refer to Exhibit 4 in front of you, please?
Again.
What is Exhibit 4?
Well, this is the exact copy of the email I received in 2003 from Ms. Langley regarding the second in-house study.
Is this a true and accurate copy of the email you received from Ms. Langley?
Yes, it is.
Your Honor, plaintiff offers Exhibit 4.
Is there any objection to Exhibit 4?
Yes, Your Honor, to hearsay.
Any responses to hearsay?
Yes, Your Honor, this email was written by Lush Fertilizer or representative, which makes the email an admission of a party opponent under 801 D2D. Therefore, it is not hearsay.
Response, Your Honor.
You may.
If I may make an offer of proof.
You may.
We have another witness that will testify in just a few moments that this email was not actually sent by Lush Fertilizer. There's a genuine question about the authenticity of this document, and as such cannot be admitted under 801 D2.
Any reply, Mr. Markle, given that offer?
Yes, Your Honor, I believe they are objecting to authenticity with that offer of proof. And under Rule 901B1, a document can be considered to be authentic if a witness with knowledge testifies that the document is valid and is true and what it is claimed to be. If opposing counsel has further questions regarding authenticity, they can address that within the scope of cross-examination.
I'm going to generally agree. I think we've reached the required level for admissibility and authenticity. I'm going to note the objection under Exhibit 4, find that we have a basis for a party opponent statement. Exhibit 4 is admitted.
Ms. Durst, can you look at the distribution list of Exhibit 4? Is Blake Doncourt listed in the recipients?
Yes, he's right there, or excuse me, she's right there. She received this email.
Now, did anything concern you about this email?
Well, it was extremely concerning that this study was studying whether Drufo was carcinogenic in humans.
1 second, Your Honor. We're working on screen sharing the exhibit. All right. Ms. Durst, I would like you to read a specific statement from this document. Could you please read the first line of the second paragraph for the court?
I can, although I am not sure the exhibit is fully on the screen.
I agree. At this point, it looks like we still need to click the share. There we go.
Following our lab June Drufo study, concerns have arisen regarding generalized findings of potential carcinogenic qualities identified in samples produced during a period early in the year.
Now, did anything concern you about this statement?
I mean, yes, this study was studying whether Drufo was carcinogenic in humans, not rats, humans.
Now, Your Honor, plaintiff offers the annotated copy of Exhibit 4 as Exhibit 4A.
Any objection?
No objection to that, Your Honor.
And I want to make sure I understand, what are we admitting as Exhibit 4A?
We are offering the annotated version of Exhibit 4 with this highlighted portion on the screen.
Is there a rule of procedure that allows the admission of a modified exhibit?
Yes, Your Honor, under Rule 4.7 of the Rules of Competition, we are allowed to admit the annotated version of Exhibit 4 with the court's discretion.
Give me just a moment. At this point, and I don't think it's 4.7, but I believe I know the rule that you're referencing in terms of the process, 4.7 supplemental materials and costumes. I'm going to decline to admit a duplicate exhibit that's been highlighted. However, certainly as a demonstrative exhibit, you may use the highlighted exhibit in the closing arguments because Exhibit 4 is admitted. So I'm allowing it as a demonstrative exhibit. You may use the demonstrative exhibit in closing. I'm not separately admitting the marked and unmarked versions of the exhibit. So with that, you may proceed.
Your Honor, just to clarify, we ask that it's also shared with the jury for demonstrative purposes.
Absolutely. At this point, the jury will have seen this. That would not have been at a sidebar. It was a demonstration before the jury. They've seen that. And certainly in your closing arguments, if you have the highlighted copy, the jury can see that as well. It just won't go back to them in a theoretical jury room.
Yes, Your Honor. Ms. Durst, from your personal involvement, do you believe there is an agenda?
From working at Lush for several years.
Objection, Your Honor, speculation.
Any response?
Yes, Your Honor. This testimony is allowed under Rule 701 as it is based on the witness's rationally based perception. It's helpful to understand her testimony to determine the issue. And finally, there's no specific scientific or specialized knowledge requested by this question. This is based on her rationally based perception of the circumstance at Lush Fertilizer.
Response, Your Honor.
You may respond.
Ms. Durst was testifying if Lush had an agenda. If Ms. Durst is allowed to testify about her own personal experiences and observations, but this is getting inside the mindset of an entity, which Ms. Durst is unable to do.
I'm going to sustain basically, I think we're talking about speculation. It overlaps into 701 or 702, and I understand the argument, but I'm going to find there's an insufficient foundation for her that's been presented so far, upon which I conclude she has personal knowledge to conclude if there was an agenda or otherwise. Certainly, Mr. Markle, I'll let you lay additional foundation if you wish to do so, or you could move to a different area.
Yes, Your Honor. Ms. Durst, when was the analysis from this study concluded?
It would have been concluded in December of 2003.
And what happened next?
Well, I had a staff meeting. These were regular occurrences, and this is where one researcher brought up concerns that Drufo was not only carcinogenic, but linked to lymphomas and leukemias.
After all of this concluded, did you ever hear anything about the study?
Well, I got a report on my desk a couple weeks later, and it basically said that Lush fit within, or excuse me, Drufo fit within the FDA standards, but it highly suggested baking Drufo. Baking Drufo would eliminate any possible chance of carcinogenic effects.
Do you believe this report was completely accurate?
No, there was clearly information left out.
Now, based on your personal knowledge, was Drufo important to Lush Fertilizer's success?
Oh, absolutely. Drufo was the goose that laid the golden egg. And to me, it seemed like it was extremely important to Lush's success.
What happened after to your job after the report came out?
Well, coincidentally or not, right after I submitted my honest report about Drufo, my performance reviews started to tank.
Did you ever talk to Ms. Doncourt about your concerns about not being treated fairly?
Yes, we had several conversations, and she basically seemed she had bigger fish to fry, or in her case, oceans to save, and completely dismissed my extremely valid concerns within the company.
And what did you do after hearing all of this?
After this, I looked at for another job, and I found more opportunities at Terrace Greenery.
Thank you, Ms. Durst. No further questions, Your Honor.
Thank you. Is there any cross-examination?
Yes, Your Honor.
You may proceed.
Good evening, Ms. Durst. I just have a couple questions for you today. You used to work for Lush Fertilizer, correct?
That's right.
And you were fired for poor performance.
I was fired, and I believe this is because, like I said, my performance review started to tank, and this is all due to my honest reports I submitted about Drufo, and they just didn't fit, it seemed to me, in what Lush wanted me to find.
Ms. Durst, that wasn't quite my question. All I asked was if the official reason you were fired was for poor performance, and it was, wasn't it?
It was, although I do not feel like that is an accurate representation of my work.
So that's a yes to my question?
Yes.
And Blake Dawncourt didn't stick up for you while you were being fired?
No, it was more that she didn't stick up for me when I brought up concerns that there were issues going on within the company, and things didn't seem to be going right within the company and with the research.
Ms. Durst, you're getting a little bit ahead of me. All I asked was if Ms. Dawncourt stuck up for you while you were being fired, and she didn't.
No, I don't believe she did.
You felt hurt by this.
Well, you see, after we had that conversation, I looked for other job opportunities. So for me, I knew that after several conversations with Blake that didn't go well, I looked for other opportunities and I got a job at Terrace.
Ms. Durst, you felt betrayed by Blake Dawncourt, yes or no?
Yes.
And you now work for Terrace Greenery?
That's right.
And you're working on a new product at Terrace?
Yes, I take great pride in my work, and we're actually working on a very successful product soon.
Exactly. And you're hoping that your new product will overtake Lush's as the best-selling fertilizer on the market.
I do not hope that, but I do believe that that could be in the future. We worked really hard on this product, and I, again, take great pride in my work. So I hope through this hard work that could be achieved.
But Ms. Durst, you specifically are hoping that your new product will overtake Lush's as the best-selling fertilizer on the market, correct?
I mean, doesn't anyone who works for their company hope that they have the best product in the company? I feel like that's pretty logical.
All right, Ms. Durst. Going back to when you did work for Lush, you were hired on as an intern, correct?
That's right.
And when you did your research in early 2003, you were an intern?
Yes, I was actually promoted 3 months after. So some of this research would have been while I was also on the development team.
But as an intern, you didn't have access to what your project manager put into her reports.
Jerry Langley has a very different job description than I. I can only testify on the specific chemical compound found in Drufo and the several in-house studies I was involved in.
Exactly. As an intern, you did not have access to all of what Ms. Langley put into her reports.
No, but I was also heavily involved in staff meetings where not just interns expressed concerns about Drufo.
Ms. Durst, that wasn't quite my question. All I asked was if, as an intern, you had access to what your project manager put into her data reports, and you didn't, correct?
No.
Objection, Your Honor. I believe this is asked and answered.
Going to overrule, the answer didn't answer the actual question, went beyond that. And so I find it's appropriate in terms of the witness control. Objections overruled. You may ask the next question.
Mr. Stephen, further on, when you were promoted, you still didn't have access to all of the data.
No, I don't believe every scientist would have access to the data. So no.
There were multiple other members of the research and development team.
Yes.
And you didn't have access to their analyses either.
No, but Lush upper management did.
But Ms. Durst, all I'm asking is that you didn't have access to their analyses, and you didn't.
Like I previously said, no, but other upper management did.
Finally, Ms. Durst, from the time you were hired on at Lush as an intern to the time you were fired, you didn't have access to all of the data.
I mean, not every researcher does, but I did have access to the data that I researched, and this data was extremely important.
For the witness, I'm going to ask you to not expand upon the questions. You need to answer the yes or no questions appropriately. This is non-responsive. Please answer the question as asked.
Ms. Durst, I'll ask you one more time. From the time you were hired on as an intern to the time you were fired, you didn't have access to all of the data, correct?
No, I did not.
Thank you, Your Honor. I have nothing further.
Is there any redirect examination?
Yes, Your Honor, briefly.
Please go ahead.
Ms. Durst, you testified that you work on teams at Lush under the research team, correct?
That's right.
And not everyone had did everyone have the same access to information?
Well, my job was to research one chemical compound found in Drufo, and I found harmful effects of this compound. Although I was not involved in every single study or knew what every researcher studied, I knew that from my research, Drufo had potential carcinogenic effects.
And was your research and the data that was available to you, was that sufficient to testify today?
Yes, I believe that makes me credible in today's trial.
No further questions, Your Honor.
Thank you. And may this witness step down. Ms. Durst, thank you very much. You're free to step down. Is the plaintiff ready to call your next witness?
Yes, Your Honor. Plaintiff calls Dr. Casey Rogers.
All right. And I see we've got Dr. Rogers. You've been previously sworn. In that case, Mr. Stewart, when you're ready, you may inquire.
Good evening, Dr. Rogers. Can you please state your name and spell your last for the record?
Yes, hello, my name is Dr. Casey Rogers. That's Rogers.
What is your occupation?
Well, I'm currently a professor at UC Berkeley in sunny California.
Have you been asked to reach some opinions in this case?
Yes, I have.
Have you reached those opinions?
Absolutely.
Let's talk about your background. Can you describe your education?
Of course, well, I have my bachelor from Colorado State in agriculture and chemistry, and then my PhD from UC Berkeley in horticulture and entomology.
You said you were a professor. What classes do you teach?
Well, I currently teach 3 courses, 2 on horticultural entomology and 1 on herbicide selectivity and action. My students say I'm a painful grader.
What kind of research are you currently involved in?
Well, most of my research focuses on mitigating harmful effects of chemicals on the human body.
Have you done any research on Drufo?
Yes, I have. I've actually written a couple articles on the subject.
Can you go into some detail about those articles?
Of course. Well, back in 2017, I believe I wrote an article on Drufo toxicity and carcinogenity. And then in 2019, I had an article on the evidence of human exposure to Drufo. And who could forget my article on multiple exposure to Drufo?
Dr. Rogers, have you ever testified as an expert witness before?
No, this is my first time testifying.
Even though this is your first time testifying, has your research been used in litigation?
Yes, to my knowledge it has, and to provide recommendations to advisory boards and agencies.
You have a bachelor's of science and a PhD in agriculture. Would you consider Drufo an agricultural product?
Yes.
Your Honor, plaintiff offers Dr. Casey Rogers as an expert in the potential effects of exposure to horticultural chemicals, including Drufo, on humans.
Is there any objection or voir dire?
Yes, Your Honor, permission to conduct a voir dire.
You may.
Good evening, Dr. Rogers.
Good evening.
Now, just to clarify, you aren't a medical doctor, right?
Yes, that's correct. I'm a scientist, no medical affiliation.
Exactly. Because you're a doctor, you never went to medical school?
Yes, that would be correct.
Meaning you don't have any training in any formal training in the treatment of a disease?
Yes, that's correct as well.
You don't have any formal training in the diagnosis of a disease?
No, I'm only a teacher and a researcher.
Right. And because you have no training and experience in either of those things, you have no training or experience in diagnosing an individual with cancer, do you?
Yes, that's correct. Not directly medically, although I do have some background on the subject because of my research.
So just to clarify, you have no experience or training in diagnosing any individual with cancer, right?
Yes, once again, ma'am, I'm not a medical doctor.
Your Honor, at this point in time, the defense does not object to the tendering of Dr. Casey Rogers as an expert in the effects of toxicants on the human body, as long as that does not include any specific testimony on medical diagnoses or conditions that an individual may have. Given Dr. Rogers' expert report, we believe that there is a tendency that she might try to testify to Dakota Weir's non-Hodgkin's lymphoma and what may or may not have caused it. So barring that, the tendering does not include any medical opinions and expertise within that area, we have no objection.
Mr. Stewart, do you have any response?
Yes, Your Honor. In Rule 702, an expert witness must have extensive knowledge, skill, experience, training, or education in an area. Dr. Rogers has sufficient experience in the area of dealing with cancers through her research. Her research deals with the mode of action of chemicals, which includes the effects that chemicals have, such as causing cancer. Through this, she can reasonably talk about the effects of cancer based on how they have affected her patients and subjects in the past.
Your Honor, if I may respond.
Before you do, I just want to make sure I understand, Mr. Stewart, what is as an offer proof outside the hearing of the jury, what is the opinion you intend to elicit as to the effects of cancer? So I'm aware of where we're going.
We seek to just point out a couple important facts about non-Hodgkin's lymphoma. One, that it's entirely environmental, so it can't be gotten from genetics. It can't be cured. That's another thing that we seek to show through her testimony. And third, we want to show that Ms. Weir's exposure to Drufo caused her cancer. Those are the things that we seek to use with her cancer diagnosis.
All right. And then with that, certainly, Ms. Combs, go ahead and you can respond.
Yes, Your Honor. Barring those three things that opposing counsel mentions, the only thing we would object to is the last opinion that they're trying to get out of Dr. Casey Rogers today. As she just testified, she is not a medical doctor, has no experience or training in diagnosing anyone with the disease, much less cancer, and thus can't testify to what or what did not cause an individual to be diagnosed with a certain disease.
All right. Both of you cited the correct rule in terms of Rule 702 and the standard. I would agree if she were going to testify as to a diagnosis, for instance, that Ms. Weir has cancer or has Hodgkin's lymphoma. I don't think she's qualified to make that type of diagnosis. As to causes, though, I think it's an area that non-medical experts can testify to. It'll be an issue of weight. So she will be accepted in terms of the effects of the chemicals on the human body, and including a potential opinion as to whether or not exposure to Drufo can cause cancer. With that, objection is noted, otherwise overruled, and you may continue. So Mr. Stewart, go ahead.
Dr. Rogers, you said you reached some opinions in this case. What are they?
Well, my opinion today in this case that there is a high degree of probability that Ms. Weir's cancer, non-Hodgkin's, was caused by exposure to Drufo. And I reached this through the data in my personal study.
Let's talk about Drufo. What is Drufo?
Well, Drufo is a bonding agent used specifically in Lush fertilizer products.
Was it invented by Lush fertilizer products? Lush fertilizer?
Yes, it was.
When did you first become concerned about Drufo?
When Drufo first came on the market, I was very concerned that it was under-researched, and that's why I conducted my own study to see if there were any risks when using the product.
Let's talk about your study. Can you go into some detail about the procedures of that study?
Of course, well, my study included 3 groups, kind of like a triangle, you might say, the Holy Trinity. I used a group that had no exposure to Drufo, and I compared them to 2 groups that had moderate exposure to Drufo and long-term exposure to Drufo.
What were the results of your study?
Well, my study showed an increase in serious medical diagnoses, including cancer, in the people who were exposed to Drufo over long periods of time. Specifically, my long-term exposure group experienced 10 times more likelihood to develop serious illnesses.
Who's to blame for this increase in cancer diagnoses?
Well, I would say that because my study focused on Drufo, and Drufo is a lush fertilizer product, it would be lush that is putting people in danger.
Have you reviewed Ms. Weir's employment records?
Yes, I have, and her medical records as well for the case today.
From those, were you able to determine the degree of exposure Ms. Weir's had?
Objection as to hearsay.
Any response?
Your Honor, as an expert witness, Dr. Rogers can talk about what group Ms. Weir's would be put into, as it's her own research. She can reasonably talk about the groups and who studies and who would fall into those groups.
And then you reply.
Yes, Your Honor, I was objecting to the employment records of Dakota Weirs as an out-of-court statement being used for the truth of the matter. Furthermore, I would object to best evidence as the actual employment records themselves and the information, specific information about exactly when Dakota Weirs was working, what they were exposed to, that kind of thing is not something that Dr. Rogers can provide and is necessary for the jury in coming to a decision today.
Under Rule 703, I'll allow her to testify as to the conclusion without exposing necessarily the inadmissible basis. Evidence is the basis for it, unless that comes out on cross-examination. So if the question is posed, I'm going to overrule the objection. She can testify as to her conclusions, even if they're based on the evidence, but I would preclude her from testifying as to what the hearsay evidence was itself. With that, Mr. Stewart, go ahead.
Based on these employment records, what group would Ms. Weirs fall under?
Yes, Ms. Weir's exposure is very similar to that of my long-term exposure group.
What type of cancer did Drufo cause in your study?
Well, we saw endocrine and exocrine cancers, of which non-Hodgkin's is one.
Do you know what type of cancer Ms. Weirs has?
Well, yes, I've previously heard her talk about it. She has non-Hodgkin's lymphoma, which is one that we saw a lot in my study.
Based on all of your analysis and your research, what conclusion do you come to about Ms. Weirs' exposure to Drufo?
Well, my conclusion is that Ms. Weir's non-Hodgkin's lymphoma was caused by her prolonged to Drufo in accordance with my study.
Thank you. No further questions, Your Honor.
Thank you. And Ms. Combs, if you're ready, you may inquire. You may cross-examine.
Yes, Your Honor. Good evening again, Dr. Rogers. I want to talk about the study you just mentioned on direct examination. Now, just to clarify, that is a statistical analysis, right?
Yes, you could say that. It compares different groups statistically.
Exactly. And you would agree with me that statistical analyses, they only show correlation.
Which correlation would you be referring to?
The correlation between the 2 factors you were testing in your study.
Well, I was only testing one factor, the correlation of Drufo and cancer and other diagnoses.
The correlation between Drufo and health conditions, right?
Yes, that's correct.
So correlation, it doesn't necessarily, or doesn't even prove causation, does it?
Well, that is frankly how science works. I can prove with a high degree of probability certain things, but no scientific expert can ever give you hard facts or evidence. That's just how the scientific process is conducted.
So that's yes to my question. Correlation in statistical analyses does not equate to causation.
Yes, as with any scientific endeavor, ma'am.
Right, and I want to talk about your attempt to find causation in this study. As you stated on direct examination, there were 3 groups, right?
Yes, that's correct.
And the group that was most highly exposed to Drufo consisted of farm laborers and gardeners. Isn't that right?
Yes, that's correct as well.
Just to clarify for the jury, those farm laborers, they were exposed to other fertilizers, weren't they?
Well, yes, they were exposed to other chemicals, as in the other ingredients of Lush fertilizer products, for instance. But the independent variable was Drufo itself, and that is what my study tests.
I'm sorry, Dr. Rogers, I think you misunderstood. They used other products other than Drufo and Lush fertilizer products, didn't they?
Yes, but Drufo is the independent variable.
Right, it was your independent variable, but those farm laborers were exposed to chemicals, pesticides, and fertilizers other than Drufo, correct?
Yes, that would be correct.
And because of that, you weren't able to isolate your causal factor, weren't you?
Well, the causal factor is Drufo, and that is what my study determines.
Right, but you were trying to test Drufo's impacts on an individual's health conditions, correct?
Yes, that's correct.
But the people you were testing were exposed to things other than Drufo.
Yes, but my study measures Drufo only, not these other factors.
But those other things those farm laborers were exposed to also might have caused those health conditions to arise.
Well, there is a possibility, but that is not what my study focuses on.
So there's a possibility that those other chemicals those farm laborers were exposed to may have caused those health conditions.
Just as there's a possibility that you might explode.
So that's a yes to my question.
Yes.
Lastly, Dr. Rogers, you didn't separate the farm laborers who used Drufo from the ones who use Drufo and other products, did you?
I'm not sure what you mean. Well, I had farm laborers and gardeners in the same group, if that's what you're talking about.
So you didn't have farm laborers who only use Drufo and farm laborers who use Drufo and other products tested separately, did you?
No, that is not what my test measures. It only compares people to the control group.
Right. It didn't measure just farm laborers who used only Drufo, did it?
No, once again, we use farm laborers and gardeners for our testing for a broader array of people.
So that's yes to my question. You didn't test farm laborers that only use Drufo.
Yes, I suppose you would be correct.
Thank you, Dr. Rogers. Your Honor, I have no further questions at this time.
Thank you. Was there any cross-examination?
No redirect, Your Honor.
I'm sorry, that was what I actually meant to ask. My apologies. No redirect. In that case,
Plaintiff rests, Your Honor.
thank you very much. Dr. Rogers, you may step down. A plaintiff rests their case in chief. Let me give my scoring panelists a moment to write down any scores before we go to the defense case. All right, and with that, then we'll go ahead and move on to the defense case in chief. Is the defense ready to call their first witness?
Yes, Your Honor. At this time, the defense calls Blake Doncourt to the stand.
All right, and Ms. Doncourt, you've been sworn in previously, and so with that, then, Ms. Radowski, when you're ready, you may inquire.
Good evening. Please introduce yourself.
Good evening. My name is Blake Doncourt.
Tell us a little bit about yourself, Ms. Doncourt.
Well, I am a heli-skiing enthusiast. I occasionally enjoy scuba diving, but I also am the CEO of my company, Lush Fertilizer.
How long have you worked at Lush for?
Oh gosh. Well, I built Lush from the ground up. It's been about 20 years, right around the time I got into heli-skiing as well.
And as the CEO, what are your main roles with the company?
Gosh, I do a lot for my company. I'm involved in some product development. I run financial analyses. I do whatever I need to.
Ms. Doncourt, as a company, what exactly does Lush do?
We as a company make fertilizer. More specifically, we make fertilizer that is environmentally friendly. We want people to have their green grass without ever worrying about harming the environment.
And how are you able to do this?
We do this by using a chemical called Drufo.
What exactly is Drufo?
Oh, what's a good way to put this? Drufo is a bonding agent. It's kind of like the buckles on a ski helmet, how those buckles connect the two sides together. That's what Drufo does with our product and the grass.
Has your company ever conducted any safety studies into Drufo?
Yes, we have.
Do you know the results of these studies?
I do. As far as I am aware, all of the studies show that Drufo is safe.
We heard earlier today from Casey Rogers. Have you ever heard of Dr. Rogers' study?
Gosh, I have, but it wasn't until very recently. I was actually on my Hellas trip in the Swiss Alps when this got brought up, right when this litigation started.
Had you ever heard of this study before that?
No, not at all.
We also heard today from Carson Durst. Do you know who Miss Durst is?
I do. Miss Durst and I would occasionally be ski buddies.
Who was Miss Durst?
She was a former employee. Unfortunately, she was let go from our company.
What happened?
Miss Durst was fired due to some poor performance reports.
Miss Durst earlier mentioned a document that she said was an email. Did you receive this email?
No, that email is totally fake.
Well, Ms. Doncourt, what makes you say the email is fake?
Well, right around the time that this whole mess started, we turned over our email servers to the plaintiff lawyers, and they searched the entire system. They never found this email within our system.
Ms. Durst also mentioned something called baking. What is baking?
Baking is a manufacturing process. It's a very high energy process where you apply a lot of heat to a product.
Did you bake your fertilizer?
No, we did not.
Why not?
Like I said, all of the studies that I was aware of showed that Drufo was already safe, so we did not bake it.
Would it have cost you any money to bake Drufo?
Oh, yeah, of course. Everything costs money nowadays.
Was this a major factor in your decision?
You know, it was a factor. It was definitely something we considered, but a major factor, no.
So ultimately, Ms. Doncourt, why exactly, what were the specific reasons why you chose not to bake Drufo?
We chose not to bake Drufo because it was already safe.
And finally, Ms. Doncourt, did your company take all of the necessary steps and precautions to ensure that your fertilizer was safe?
We absolutely did.
Thank you, Your Honor. I have nothing further.
Thank you. Is there any cross-examination?
Yes, Your Honor. Ms. Doncourt, before we begin, I just want to confirm, you never mentioned skiing or scuba diving in your witness statement, correct?
No, I did not think it'd be appropriate to talk about my annual skiing trip in an affidavit that involves my company.
All right, thank you. And you testified that you are the CEO of Lush Fertilizer, correct?
Yes, I am.
And your toxicology expert performed a study, correct?
Yes.
And your only information about Drufo comes from only your research and development team in Lush's studies, correct?
Yes, we do our in-house studies, and that's where I get most of my information.
My question was, is that where all of your information comes from? Is that correct?
That is where our information comes from. That would be correct.
So are you saying that you don't believe independent studies are important?
Oh, no. I'm just saying that within Lush Fertilizer, we do our in-house studies, and that is our information.
Now, my question is, do you believe that that independent studies are not important, correct?
Independent studies are of course important. However, when considering our product, we did in-house studies. That was a choice of our company.
Yet you didn't review any other independent studies.
No, we did not.
Now, Devin Williams led the research effort at Lush, correct?
Yes,
And it's your testimony that there's little to no risk using your fertilizer.
it absolutely is.
Now, let's talk about what you left out. You never reviewed any other studies, did you?
That's simply not my job. I'm CEO of the company. I approve products.
You heard Carson Durst testify today, correct?
Yes, I did.
You didn't know about the English study she testified about, which pointed to carcinogenic effects in adolescents.
Objection, Your Honor, argumentative.
Any responses to the objection?
Your Honor, this is not argumentative. I am asking a question about whether she had seen this study before this case.
A response, Your Honor.
You may respond.
I'd like to raise a second objection to facts not in evidence.
I'm going to overrule that. I think we've had testimony as to a potential that there was presentation of information. Whether this witness knew or that or not, I don't think is improper in terms of that. So I'm going to overrule both objections. You may answer the question.
Ms. Doncourt, did you know about the English study Ms. Durst testified about?
Oh, I have no knowledge of that before today.
And you hire the research supervisors as CEO, correct?
Yes, I do.
Therefore, to make a safe product, you would ensure that your research supervisor is reviewing all the important information, correct?
I hire the research supervisor based on, my opinions of who's best for the job. What they do on the job is their responsibility.
And they would relay the important information to you, correct?
Yes.
Now, Ms. Doncourt, Lush conducted multiple studies on Drufo, right?
That would be correct.
And you are aware that you were sent an email regarding a second study on Drufo.
Nope, I was never sent an email.
Can you look at Exhibit 4 in front of you, please?
Counsel, would you mind screen sharing that? I do not have that exhibit pulled up.
Look at paragraph 2 of the email for me. Doesn't it say, following our lab's June Drufo study, concerns have arisen regarding generalized findings of potential carcinogenic qualities identified in samples? Did I read that correctly?
You read the fake email. Excuse me.
And this email states that you needed to perform a second study, correct? Your Honor.
Your Honor, could I ask for a brief break?
We can give our witness a moment to, I know she's got a cough in terms of that. Tell me if you need more time, but we'll take just a moment.
I think I will be okay now, Your Honor. I appreciate that.
Thank you. I'll go ahead and we'll come back to the question. Mr. Stewart, go ahead.
Now, Ms. Doncourt, Exhibit 4 states that you needed to perform a second study, right?
The fake email does state that.
And Ms. Doncourt, look at the recipient list of Exhibit 4. That's your name in the recipient list, isn't it?
On the fake document, my name is.
Ms. Doncourt, I'm not asking about your opinions on its validity right now. I'm asking specifically about Exhibit 4. That is your name in the recipient list, isn't it?
My name is on that document.
And the importance of the email in Exhibit 4 is listed as high, yes or no?
Yes, that would what the document says.
If you receive an email marked as high importance, you would read it, wouldn't you?
I would, except I didn't receive this email.
Now, let's talk about baking Drufo. You know what baking Drufo means, right?
I know what baking is, yes.
Isn't it true that if you bake Drufo, it would eliminate any carcinogenic effects, correct?
Any minimal risk.
But Lush doesn't bake it, do they?
No, we do not. Drufo is safe.
You would agree that baking Drufo is costly, yes?
Everything costs money, of course.
When Lush decided not to bake Drufo, cost was one of the reasons Lush decided not to bake it, wasn't it?
It was a consideration. not the sole reason. Our main reason was that Drufo was
Ms. Doncourt.
already safe.
You even created an amortization table for baking Drufo, didn't you?
Yes, I did.
And creating these cost benefit analyses is a regular practice of Lush, correct?
I create financial analyses, yes.
You're on, Ms. Doncourt, can you refer to Exhibit 8 on the screen?
Yes, I can.
What is Exhibit 8?
It's a document that I created.
Is this the spreadsheet that you created to analyze the cost of baking Drufo?
It is.
And is this a true and accurate copy of the spreadsheet you created?
Yes, it is.
Your Honor, plaintiff offers Exhibit 8.
My apologies. Is there any objection to Exhibit 8?
No objections to Exhibit 8, Your Honor.
All right, Exhibit 8 is admitted. We'll presume it was outside the presence of the jury. You may show Exhibit 8 to the jury if you wish.
Ms. Doncourt, this document shows how much revenue your company would lose if they had baked Drufo, correct?
It shows that, among other things, yes.
Look at line 10, and on the far right side of that line, the estimated overall revenue loss from 2004 through 2014 is $2,615,553, correct?
That's correct.
Were you here when Dakota Weirs testified today?
Yes, I heard Ms. Weirs.
Do you recall that this is the same amount that Dakota Weirs is asking for damages?
I believe so.
And this is also how much money Lush saved by not baking Drufo, isn't it?
That is how much money would have been spent had we baked Drufo, correct?
And you needed that money to pay your investors, didn't you?
We are a company. We are expected to output profit.
Now, your priority then was making a profit for Lush, wasn't it?
Objection, Your Honor, argumentative.
Any responses to argumentative?
Your Honor, this is not argumentative. I am simply asking whether Ms. Doncourt's priority was making a profit for Lush. That's not argumentative.
Now
Response, Your Honor.
You may respond, yes.
That would be counsel testifying.
At this point, I'm going to overrule to counsel testifying, but let me just address to argumentative. Is there a good faith basis that the witness will agree? I'm sorry, Mr. Stewart. In other words, do you believe that the answer to this question is going to be yes?
Yes, Your Honor.
All right, objection is overruled. You may ask the question.
Ms. Doncourt, your priority was making a profit for Lush, wasn't it?
As a company, we have two priorities. We like to make safe products, but we would also like those products to generate revenue.
Ms. Doncourt, if Lush cared about safety, they would have warned its users, wouldn't they?
We put a product on the market that was safe. A warning label was not necessary.
If Lush's priority was safety, they would have baked the Drufo, wouldn't they?
Our product was already safe.
No further questions, Your Honor.
Is there any redirect examination?
Yes, Your Honor. Ms. Doncourt, you were asked, my apologies.
Please go ahead. You may proceed.
Ms. Doncourt, you were asked on cross-examination about baking. Why didn't you bake your product?
Well, like I said, all of the reports that I had knowledge of showed that Drufo was already safe without baking it.
And you were also asked about an email. Is this email real?
No, that email is completely fake. I never received it.
And why exactly do you say that it's fake?
Well, like I said, our email servers were searched and this email was nowhere to be found on them.
Finally, Ms. Doncourt, you were asked on cross-examination about the studies you conducted. What were the results of these studies?
All of the studies showed that Drufo was safe.
Thank you, Your Honor. I have nothing further.
Thank you. And may this witness be excused?
Yes, Your Honor.
Okay, she may step down. Is the defense ready to call its next witness? Actually, I should give a moment for our scoring panelists. My apologies. I'm jumping a little ahead. We'll let them get scores written down. And as they do so, is the defense ready to call its next witness?
Yes, Your Honor. The defense calls Ms. Skylar Weirs to the stand.
All right, Ms. Weirs, I'll let you take the witness stand as well. You've previously been sworn. And when you're ready, Ms. Combe, you may inquire.
Good evening. Could you please introduce yourself to the jury?
My name is Skylar Weirs.
Ms. Weirs, what do you do for a living?
Well, I call it many things: truth-seeking, truth-finding, but I suppose the lay term would be investigative journalism.
Who do you write for?
I write for Rationalist magazine.
What does your typical process look like when writing for The Rationalist?
Well, when I'm just starting a series of articles, I'll start at a very broad level of knowledge, but then I'll look at what topics I think are interesting or relevant or important, and I'll zero in on those.
Now, just to clarify, it was mentioned many times earlier in this trial that you write articles about conspiracy theories like UFOs or flat Earth for The Rationalist. Is that true?
That is simply not true. The only time I've ever written about conspiracies is to debunk them, and I would never waste my writing skills on some 2-bit conspiracy website.
So what have you been tasked with writing about recently?
For the past year, I've been working on a series of articles about modern agritech.
Did you follow the same process of getting a broad base of knowledge and then zeroing in with your research in modern agritech?
Of course. I started by looking at some of the most important studies and researchers in the field. And then after that, I started to follow various rabbit holes. I looked at studies referenced in other studies. I tracked down a lot of information from the government, including the Department of Agriculture, as well as the National Association of the State Departments of Agriculture.
Ms. Weirs, how long did you spend researching modern agritech?
Well, like I said, it's been about a year, but this hasn't been a regular 9 to 5 for me. It's might be closer to a 12 to 12. I burn the midnight oils researching a lot, and sometimes I don't sleep for days on end.
Ms. Weirs, do you look at resources from agritech companies in your research?
Of course.
Your Honor, the defense moves to enter Skylar Weirs as an expert in modern agritech.
Any objection or voir dire?
Yes, Your Honor.
Go ahead.
One moment, Your Honor. We're having audio issues. Is that better?
That's not echoing. Please go
Thank
ahead.
you, Your Honor.
Perfect. Thank you.
Ms. Weirs, briefly, nowhere in your witness statement does it say that you research so much you don't sleep for days on end, correct?
I thought that just saying that I've been researching for a year was enough.
You're only 20 years old, right?
That's right.
And your last actual form of education was high school?
I think that college is a tool of the bourgeois to keep the proletariat down. I chose to forego it.
So that's a yes to my question. Your last actual form of education was high school.
I chose to forego college, yes.
The only knowledge that you have in the matter of hand comes from research you did for articles that you wrote.
Like any other journalist, that's true.
And like you said, you've only been doing research on Drufo specifically for less than a year.
A very long year.
You've never conducted your own study.
That's not my job as a journalist. I collect studies and put them together.
So that's a no. You've never conducted your own study.
No.
And you've never conducted research or a study on your sister's specific situation.
I think that I would be quite biased if I had done a study specifically on my sister. No.
You're quite biased in writing a research paper, but you can testify in court today unbiased?
Well, if I'm writing a research paper, that's simply not my field. When I'm writing my journalistic articles, I stay as neutral as possible.
You've written articles. You haven't written any articles on cancer, have you?
No.
And you haven't published medical studies?
I'm not a doctor, no.
And the articles that you have published, they go straight from you to the reader, right? There's no expert peer review.
Well, we have an editor at Rationalist.
Is that editor a doctor?
No, he's a journalist.
Right, that editor's not a toxicologist either.
Because this is not a research paper, it doesn't need to be peer reviewed in the same way, no.
So no expert confirms that what you're giving to the reader is the truth or scientifically correct.
I know that what I'm giving to the reader is correct because I base it off of resources from experts.
Right, that wasn't my question. No expert confirms that though, correct?
As of right now, no.
You don't specify the amount of articles about agritech that you've written.
I've lost count at this point.
You don't clarify how many agritech companies you've researched.
I mean, I can give a number, about 10,000.
Where in your witness statement does it say that you've researched 10,000 agritech companies?
Well, you just asked me for the number, counsel.
You can't name any specific studies, can you?
Sure I can. There's plenty of studies from Kelson Greenery on Drufo. There's
Can
also...
you name them, or can you just name the people that have published them?
Yeah, I can name them. Kelson Greenery's study was about the effects of Drufo on the heart. There was a study named Drufo's effects on the limbs. I can keep going.
Ms. Weirs, where in your witness statement does it say these names of the studies?
I never considered it relevant to mention a particular study.
If you do not have something in your witness statement, inform me of that before you extrapolate.
I never considered it relevant to include in my witness statement, but since you've been asking me, I've been happy to elaborate.
Ms. Weirs, in your own words, you have general knowledge on the subject at hand, correct?
Yeah, and that means that I can name quite a few studies.
Your Honor, the plaintiff challenged the admission of Skylar Weirs as an expert witness in agritech, as only spending 1 year reading articles published by other researchers does not prove Ms. Weirs has any qualified knowledge or skill. Her part-time job as a magazine writer does not give her experience or training in the fields of science or medicine. Her high school education and lack of college degree prove no qualification through education. Under Rule 702, expert testimony is of scientific, technical, or specialized knowledge. Ms. Weirs has asserted that she has no scientific or technical degree, training, or education, and the only knowledge she has is general. Additionally, Judge Staub's pretrial ruling requires the witness to provide understandable explanation of her qualifications, including researching qualified agritech companies. Ms. Weirs cannot provide an understandable explanation. Therefore, she cannot be admitted in an expert in agritech.
Ms. Coleman, any response?
Yes, Your Honor. Regarding Judge Staub's pretrial motion, in order to tender Skylar Weirs as an expert within modern agritech, we needed to lay foundation and show 4 things. Firstly, that she spent a considerable amount of time researching modern agritech. She spent an entire year, and despite what opposing counsel says about this not being lengthy enough, that goes to the weight, not the admissibility of this tendering. Secondly, that she looked at research studies done by agritech companies, which she testified to, in the studies within those studies by agritech companies. And lastly, that she looked at information from governmental organizations like the USDA and NASDA. We have met all 4 qualifications and provided foundation as per Judge Staub's pretrial motion. Furthermore, during the voir dire, it was implied that Ms. Weirs was going to be testifying to technical knowledge that requires scientific basis. If I may make a quick offer of proof, Your Honor.
You may.
Ms. Weirs is simply going to be testifying to dynamics within the modern agritech industry, within what she calls a new guard and the old guard, and how lush fertilizer is being unfairly targeted by the old guard within the industry. She's not going to talk about any scientific data or facts that would require education in toxicology or chemistry or anything like that.
Particularly in light of the pretrial order and the requirements, I'm going to find that those requirements have been met, and consistent with that, I will find that she is qualified, may offer opinions pursuant to Rule 702. You may proceed.
Ms. Weirs, could you tell us what is modern agritech?
Well, what isn't modern agritech? There's Shakespearean drama, there's intrigue, there's romance. But if I had to give a dictionary definition, I'd say it's the tools and solutions used by farmers to make their process more efficient.
So when researching modern agri-tech, did you notice any recurring patterns come up?
Yes, if I may use an analogy to help the jury understand, I think that modern agri-tech is a lot like the myth of Saturn devouring his children, but Jupiter, the mightiest of his children, defeating his father. This is the dynamic that I see between the old guard and the new guard.
What is the old guard and the new guard?
Well, the old guard are essentially companies that have been in modern agri-tech since the very beginning. They've got a lot of consumers, they've got a lot of resources, they've got a lot of money. The new guard, on the other hand, are companies that are just starting to enter the industry.
So tying it back to your analogy you made earlier, what does the old guard do to the new guard?
Well, the old guard, Saturn, well, often what will happen is the new guard will introduce some kind of new product, and it'll be better than what's already out there. The old guard, Saturn, will see that this is better than what they have, and they realize they're going to lose money. So they will do everything they can to get this product off the market, just like Saturn and his infanticide.
Now, Ms. Weers, do you have any examples you can give us that shows this is a pattern within the modern agri-tech industry?
Oh yeah, I've got a lot. I suppose this happened just a few years ago with Monsanto.
What's your opinion on the situation with Monsanto?
Well, what happened with Monsanto is they introduced a new maize herbicide, and that sounds mundane. But let me tell you, from the research I did on this herbicide, it could have changed the world. If it had gone through, we might all be eating corn for every meal of every day to this day. But unfortunately, that didn't happen.
Why?
Well, the old guard saw this maize herbicide and they realized they were going to lose money. And so they waged a huge PR campaign to get this, or to turn the public's opinion around.
Was the PR campaign successful?
Unfortunately, yes. Even though it's all based off of faulty evidence, it unfortunately worked.
Ms. Weers, do you believe this same thing is happening with Lush fertilizer today?
Of course.
Objection, Your Honor.
Yes.
I think that the opposing counsel is trying to prove a character trait of the old guard and that they acted in accordance with that trait that they gained in the past in situations like Monsanto. They're acting in accordance with that currently with Lush fertilizer.
And I take it it's a 404 objection?
Yes, Your Honor, 404A and proper character evidence.
All right. And Ms. Combe, any response?
Yes, Your Honor. Ms. Weers is going under Rule 404B. This is going to show the intent of the old guard and it being a pattern in trying to usurp the new guard within the industry in order to quell any profits that they may have. Ms. Weir's example of Monsanto and the intent there goes directly to the intent of the old guard targeting Lush fertilizer today.
And why does that not fall under 404?
One moment to retrieve the rule, Your Honor.
Oh, certainly.
Your Honor, the language of 404A is that evidence of a person's character or character trait is not admissible to prove that on a particular occasion, the person acted in accordance with the character or trait. Here, the person is corporations and two different corporations at that. We're not using Monsanto in the past to show how Lush fertilizer is acting now. Those are two separate situations used to establish a pattern. Lush fertilizer and Monsanto are two completely different entities that aren't even people.
Any response, Ms. Dino?
Yes, Your Honor. So the language that opposing counsel has been using is old guard versus new guard. They're choosing to use this language to show consistency between the Monsanto case and Lush Fertilizer. They are using one single character, which is the old guard, and proving a character trait of consistency between Monsanto and Lush Fertilizer. Therefore, this is improper character evidence under Rule 404.
Understand the objection. I'm going to agree under 404A and B. However, it has to be that a particular person has a character trait. I'm not certain that entities or old guard would have a character trait, but it has to be that that person acted in accordance. So if different companies have done different things, I'm going to find it doesn't fall under 404A or 404B. Overrule the objection. Allow the question to continue. With them, Ms. Combe, it may be better. Let me let you re-ask your question and go from there.
Yes, Your Honor. Ms. Weirs, do you believe this is happening with Lush Fertilizer today?
Of course.
Why?
Well, throughout my research, I've seen no evidence to suggest that Lush has done anything wrong. I think that the pattern that I've seen has repeated over and over again. And this time it's happening to Lush.
So just to clarify, what does Lush Fertilizer and the product Drufo mean for the old guard?
The old guard is seeing Lush and Drufo, and they realized they're going to lose money.
Do you have any evidence to back this point up?
I think that this very court case is evidence in and of itself. I haven't seen any.
Go ahead.
I fail to see the relevance of this case as we're getting further away from the comparison to Lush Fertilizer. The old guard isn't suing Lush Fertilizer today. Dakota Weirs is. And so I don't understand how a theory of the old guard targeting Lush is relevant.
Any response in terms of relevance?
Yes, Your Honor. The dynamics within the agritech industry and specifically and how they relate to Lush Fertilizer is relevant to today's case because it shows that Lush Fertilizer is being targeted not because it's a carcinogenic not because of its carcinogenic properties and the impacts it has on individuals' health, but because it represents a threat to the old guard. That the old guard is manufacturing these lies about Drufo and Lush Fertilizer's new products because it means that they lose profit. It's fundamental to believing the entire case in theory of the plaintiff.
And let me ask, who is the old guard in this case?
The old guard is companies that are well established within the fertilizer industry.
But they're not parties or witnesses to the case, am I correct?
They're not present today. However, their presence is seen through the manufactured evidence relating to the carcinogenic properties of Drufo and even why we're here today in the first place.
Any reply, Ms. Dino?
Yes, once again, Your Honor, the old guard isn't present here at trial. Dakota Weirs doesn't have a history working at the old guard. None of the plaintiff witnesses has a history in the old guard. And therefore, the old guard is as far away from attacking Lush Fertilizer as possible. I don't see how this fabrication of the old guard targeting Lush Fertilizer is at all relevant to today's case.
Your Honor, if I may make a brief offer of proof.
You may.
Ms. Weirs is going to testify that the old guard being unknown to Lush Fertilizer and the general public is characteristic of the industry, that the old guard and part of its motive is to remain hidden so that the actual threat of Drufo being carcinogenic is actually believable. So Ms. Weirs is going to testify that it makes sense that we don't know the specifics of who and what companies are targeting Lush Fertilizer.
Under either 403 or 401, I think we're too attenuated. I appreciate the argument, but I will sustain the objection mostly under Rule 403 in terms of confusion of the issues. And sustain the objection, let's you ask the next question.
Yes, Your Honor. So just to clarify one more time for the jury today, Ms. Weirs, why do you think Lush is being targeted?
Well, it's just a pattern that I've seen over and over again in my research of the industry. And Like I said, in this court case, all the evidence introduced against them has been faulty or misleading.
Thank you, Ms. Weirs. Your Honor, I have no further questions at this time.
Thank you. Any cross-examination?
Yes, Your Honor. Ms. Weirs, growing up, you shared a lot with your twin sister, right?
Yeah, we did just about everything together.
Yeah, and your parents supported you both growing up.
Well, we were children, yes.
And your dad supports Dakota financially now with her medical debts, yes?
As he should.
But he cut you off when you chose not to go to college, right?
I can strike it out on my own.
That's a yes.
Yep.
And he cut you off before your sister's diagnosis, right?
I'm not sure if that's true, counsel.
Your sister was diagnosed 3 years ago, correct?
I think that's about correct, yeah.
And you chose to forego college after high school, correct?
Yes.
And your sister was diagnosed after high school, right?
Yeah.
So then your dad did cut you off after or before your sister's diagnosis.
It was about the same time.
Dakota's medical bills have nothing to do with the money that your father chose to cut you off from, right?
Well, I think that he should redirect those funds towards her bills.
It makes you angry that your father isn't helping you out financially.
No.
You resent him for not helping out financially, correct?
No.
Do you recall giving a witness statement in this case?
Yes, I did.
And you recall, one moment, Ms. Weirs. In that witness statement, you claim that you do not resent Dakota, correct?
That's right.
Nowhere in that witness statement do you say that you don't resent your father.
Because I don't.
It doesn't say that you have love for your father still, though, does it?
I don't think I need to explicitly outline that.
If Dakota wins today, that means more money for your father, correct?
More money for my family and myself.
More money for yourself?
Well, part of it could end up in the will.
Let's go on to your research, Ms. Weirs. The vast majority of it is about GMOs, right?
I've done quite a lot of work on that, yeah.
And you've only ever published one article relating to Drufo.
Yes.
And in that article about Drufo, you write about it in the context of nitrogen and waterways, and very little about the causal link between Drufo and cancer.
Well, that was before I had done research on its carcinogenic properties.
Right, but you have not published an article relating to Drufo's link to non-Hodgkin's lymphoma, correct?
Objection, Your
I have a
Honor.
whole-
Relevance, if I may be heard briefly.
You may, go ahead.
Your Honor, Ms. Weirs is here today to testify on the dynamics within the modern agri-tech industry. She wasn't tendered as an expert in toxicology or chemistry and finding the causal link between Drufo and cancer. Thus, asking questions about those two things is, one, outside of her expert testimony, and two, isn't relevant to what she's here to talk to us all about today.
Ms. Dino, any response?
Yes, Your Honor. Ms. Weirs is testifying that the claims about Drufo in relation to cancer against Lush Fertilizer are false. That is the plaintiff's main claim today. And so their argument that this is the old guard's idea, they fabricated this idea of Drufo causing cancer, that has specific relation to his testimony. I'm trying to prove through this testimony that he has no real knowledge or specialized knowledge in relation to Drufo and cancer, and therefore cannot testify to if the old guard is using that claim against Lush Fertilizer.
I think there's some potential relevance. We can go too far with this and the sideshow getting ahead of the circus, so to speak. I will allow a limited series of questions on this. You may inquire.
In the article that you published about Drufo, you don't talk about a causal link between Drufo and cancer.
I've got a whole series of articles discussing that lined up, but in that one article, no.
The reason that you advocate for Drufo is because it's a safer alternative to other fertilizers.
That's what I've seen from all my research, yeah.
Can you name any of the other fertilizers that Haven uses?
I'd love to. From what I know about Haven, or at least landscaping companies like that, they probably use property.
Anywhere in your witness statement, do you name the other products that Haven uses?
I never considered that relevant to include.
So you don't know what your sister was exposed to, do you?
I can make a very educated guess.
A guess.
A very educated one.
Drufo is a pesticide, correct?
That's right.
And virtually every commercial pesticide has carcinogens.
Yeah.
Non-Hodgkin's lymphoma is caused by exposure to environmental conditions, including pesticides, correct?
Objection, Your Honor.
Sure.
Again, as to relevance, I believe this is breaching the relevance of Ms. Weirs' tendering today and what she's here to talk to us about.
Any response?
Yes, Your Honor. Again, the defense is trying to claim that the reason Lush Fertilizer is being sued today is because there is an attack from the old guard to the new guard, and not because Ms. Weirs is actually diagnosed with cancer. This testimony is going to prove that Ms. Weirs' diagnosis did come from the Drufo, which disproves the defense's claim that the old guard is targeting.
I think we've strayed outside the area of the expertise and the area of the opinions as well. That's certainly an area ripe for argument, but I'm going to sustain as to questions on that. So objection sustained. I'll let you continue.
Finally, Ms. Weirs, Dakota Weirs isn't a member of the old guard of the agricultural industry, is she?
No, I think that my family has been misled by the old guard.
Dakota Weirs is the one suing Lush today, correct?
I think because of the old guard, yes.
No further questions.
Was there any redirect?
Yes, Your Honor. Starting off, Ms. Weirs, just to clarify, do you believe your sister is the old guard?
Of course not. Like I said, I think that my family has been misled by misinformation put out there by the old guard. Frankly, I'm sickened that they would prey on our family's grief like that.
Ms. Weirs, this has been said time and again today by your sister and by opposing counsel. Do you resent your sister for getting cancer?
Of course not. We're family. I don't think it's her fault.
Do you resent your father?
Of course not.
Ms. Weirs, you were asked about any financial incentives in testifying today. To clarify for the jury, why are you here?
I don't do things for the money. I'm a part-time worker at Applebee's, for God's sake. I do it because I care about the truth. That is my guiding principle.
Thank you, Ms. Weirs. Your Honor, I have no further questions.
All right. In that case, I'll let the witness step down. We'll give our scoring panelists a moment to record any scores. And with that, is the defense ready to call its next witness?
Yes, Your Honor. The defense calls Dr. Devin Williams to the stand.
All right. Dr. Williams, you've been previously constructively sworn. So with that, when you're ready, you may inquire.
Please introduce yourself for the jury.
My name is Dr. Devin Williams.
What do you do for a living, Dr. Williams?
I lead the research and toxicology labs at Lush.
Why are you here testifying today?
I'm here today to show that using Drufo leads to no increased risk in developing cancers.
Let's talk for just a moment about yourself, Dr. Williams. Do you have any education?
I do. I have my master's all the way up through my PhD.
What did you receive your PhD in?
I received my PhD in research toxicology.
Dr. Williams, do you have any certifications for your position?
Indeed, I do. I have certifications in clinical and forensic toxicology.
Apart from those certifications, how long have you been working in your field?
Let's see now. I got my PhD back in 2003, so almost 20 years now.
And in those 20 years of experience, what kind of jobs have you performed?
For sure, I joined a post-PhD program right after I got my PhD, a few jobs in between, and then eventually I joined Lush.
How long have you been with Lush Fertilizer?
I've been with Lush for 10 years, and 7 of those years I've led their research and toxicology labs.
Dr. Williams, before we get any further, could you explain what exactly is a research toxicologist?
That's a great question. Essentially, a research toxicologist works to understand how chemicals in an environment can negatively impact that environment, and then we research on how to negate those effects.
Well, Dr. Williams, are you familiar with the chemical Drufo?
I am. I've worked closely with it.
Your Honor, at this time, the defense moves to tender Dr. Devin Williams as an expert in the field of research toxicology.
Any cross-examination of voir dire?
No void deal, Your Honor.
All right, he will be so accepted. May I offer opinion testimony pursuant to Rule 702? You may continue.
Dr. Williams, could you tell us what is your main goal as a research toxicologist with Lush Fertilizer?
For Lush, my main goal is to create a safer fertilizer.
Why do you say it's necessary to create a safer fertilizer?
Older fertilizers, old guard fertilizers, leave excess nitrogen in the environment when eutrophication happens. This negatively harms bodies of water, fish life, plant life, and it's really bad for the environment and even worse for the world.
Well, if fertilizer is so bad for the environment, what do you do as a scientist to try and stop that?
Well, here at Lush, we've added a revolutionary product known as Drufo.
Could you explain what Drufo is?
For sure. Drufo is a bonding agent that leads to less nitrates being exposed to the environment when eutrophication happens. This leads to less impact on the water system, animals, plants, and it's just a whole lot better for the environment.
And Dr. Williams, does Lush Fertilizer conduct studies on its products when they're created?
Well, of course, extensive studies.
What are the goals of these types of studies?
Well, these studies are created to determine if Drufo has any adverse health effects and how we can negate those effects, if any are found.
Did you do any studies on the fertilizer containing Drufo?
I did, yes.
What was the result of those studies?
Those studies showed that using Drufo leads to no increased risk of developing cancers such as non-Hodgkin lymphoma.
After you got the conclusions of those studies, were you confident in the safety of the product?
Absolutely.
Dr. Williams, are you also familiar with Dr. Casey Rogers?
I am, yes.
Are you familiar with Dr. Rogers' study on Drufo and non-Hodgkin lymphoma?
Indeed, I am.
Could you tell us what was your general conclusion about that study?
My general conclusion about that study is the results are invalid because I found 3 fatal flaws.
Let's talk about those 3 fatal flaws you found. What was the first fatal flaw?
The first fatal flaw I found with Dr. Rogers' study is its lack of repetition.
What do you mean by that?
We can look at any diagram of the scientific method in a high school hallway, and you'll always see that the last step is to repeat the process. Repeating the process ensures that the conclusions of the first study are either supported or denied.
So what does it mean for Dr. Rogers' study that it wasn't repeated?
Without ever being repeated, there's no way of knowing if the conclusion within the study is supported or denied, and its results are invalid.
All right, Dr. Williams, let's talk about the second major flaw you found. What was that?
The second major flaw I found with Dr. Rogers' study is its lack of peer revision.
Could you explain that a little more?
For sure, the peer revision process allows other certified members of the academic community to look over a study and point out the problems with it. This didn't happen in Dr. Rogers' case, and these problems made it through to the final product, the final study.
Dr. Williams, what was the third fatal flaw that you noticed?
The third and most important fatal flaw I found with Dr. Rogers' study is the methodology.
What was wrong with the methodology?
In a study, you're only supposed to change one variable. Dr. Rogers didn't do this. Dr. Rogers took people who garden, people who don't garden, and then farm laborers. That's 3 variables right there. And on top of these 3 variables, Dr. Rogers looked into how much DRUFO was being used. That's a lot more than one changing variable.
What does it mean for the results of this study that there was more than one changing variable?
Well, with more than one changing variable, there's no way of knowing what the problem was, and if that problem was even DRUFO.
Well, if there's no way of knowing what the problem was, then what was your overall conclusion about the study?
With all these flaws, the overall conclusion of this study is all the results of it are invalid.
Dr. Williams, finally, based on everything you've told us today and everything you know, does DRUFO cause cancer?
Based on all of this, the use of DRUFO leads to no increased risk in developing cancers.
Thank you, Your Honor. I have nothing further.
Thank you. Is there any cross-examination?
Yes, Your Honor.
Stuart, when you're ready, go ahead.
Good evening, Dr. Williams.
Good evening.
Paid by Lush Fertilizer, correct?
I am employed by Lush, yes.
Blake Donacourt is your boss.
Like Donacourt is the CEO of the company, yeah.
You admit to having financial bias in this case.
Indeed, I have a small financial bias in this case.
If it's found that Lush's fertilizer causes cancer, it will have significant financial impacts on the company, correct?
Sure, it would have some financial impacts, but we would put out some studies that show the use of DRUFO doesn't lead to cancer.
Let's talk about your study. Your study wasn't replicated, correct?
It was replicated multiple times within Lush Fertilizer.
Do you remember giving a witness statement?
I do, yes.
You agreed to include everything important in this witness statement.
Indeed.
Yet nowhere in your witness statement do you say that your study has been replicated.
I figured you would assume that. We're a legitimate company and we employ highly certified members of the academic community.
So
of course our study would be repeated.
So you didn't include that in your witness statement, so we can't.
I did not. I didn't see how that would be necessary.
Verify the correctness of that, can we?
Unfortunately, you cannot.
We also can't conclude that your study was peer reviewed because it wasn't included in your witness statement, correct?
No, you'll just have to take my word for it.
Moving on, you agree that all fertilizers can be dangerous, correct?
Anything can be dangerous, so a water bottle might give you cancer.
Lush Fertilizer could have easily included a warning label about the potential long-term effects of its product.
There weren't any potential long-term effects, and I mean, heck, we even went far enough to include recommendations.
So it simultaneously has no effects, no dangerous effects, yet it is also a fertilizer, which inherently makes it dangerous. That's what you're saying?
Well, any fertilizer can be dangerous, but compared to other fertilizers, our product is truly revolutionary and truly safe.
So Lush could have included a warning label that said, warning, this product is a fertilizer and contains chemicals which may be dangerous, correct?
It could have, and we did include recommendations.
And it didn't do that, correct? It did not make a significant warning label.
There are no explicit warnings, no.
Thank you. No further questions, Your Honor.
Thank you. Is there any redirect examination?
Yes, Your Honor. Dr. Williams, why weren't there explicit recommendations about long-term effects of the fertilizer?
Well, there's no data to show that there are any long-term effects of the fertilizer. We included recommendations to keep you safe, but there's no need for a warning because there's no long-term effects.
Thank you, Your Honor. I have nothing further.
Thank you. Does the defense have any additional witnesses?
Thank you, Your Honor.
Thank you. Does the defense have any additional witnesses?
No, Your Honor, at this time, the defense rests.
All right, I want to give our scoring panelists a moment to make sure they can write down any scores and make any determinations. And in a moment, we'll be going to closing arguments. All right, with that then, we've reached the close of the presentation of evidence. We'll move to the next phase of the trial, which are the closing arguments, beginning with the plaintiff's closing argument. Is the plaintiff ready to give your closing argument?
Yes, Your Honor.
Ms. Dino, when you're ready, actually, what I'm going to also do so that we've got an audience for you, if our scoring panelists would go ahead and reactivate their cameras.
And briefly, Your Honor, I would like to confirm that all time remaining is saved for rebuttal.
That is correct. So all time remaining after your closing argument, if any, is reserved for rebuttal.
Thank you, Your Honor.
All right. And we're about there. When you're ready, please go ahead.
Ladies and gentlemen, thank you for your time and attention. Greed kills. The defense tried to convince you that the reason we're here today is because Dakota Weers was just looking for someone to blame. Contrary to their story, the reason we're here is to condemn the greed of Lush Fertilizer. Looking at the evidence, Dakota Weers' case comes down to responsibility. Ms. Weers was responsible for spreading seed and fertilizer when she worked at Haven Landscaping. Lush Fertilizer was responsible for keeping its users safe. Lush Fertilizer failed to fulfill this responsibility. It's the plaintiff's responsibility today to provide evidence and reasoning according to the law. Finally, it's your responsibility, ladies and gentlemen of the jury, to recognize the negligence of Lush Fertilizer, the fact that their greed kills, and bring justice for Dakota Weers today. 6 years ago, 14-year-old Dakota Weers was spreading seed and fertilizer like she did every day. At that time, Miss Weers felt fine, more than fine, actually. She was happy. She had her whole life ahead of her. She didn't know it yet, but she would get a scholarship to Juilliard and build a future doing what she loved. Meanwhile, Blake Duncourt was relaxing in the success of her company. 4 years later, Miss Weers could barely stand. Just like that. No more piano, no more Juilliard, maybe no more future at all. Pursuant to jury instruction number 2, the plaintiff must prove negligence by showing you that 1, Lush Fertilizer manufactured Drufo. 2, they failed to reasonably prevent risk to those using the product in the expected manner. 3, that Dakota Weers used said product in the expected manner. And 4, that Miss Weers has damages caused by Drufo. Now, let's walk through these elements one at a time. Number 1, there's no dispute that Lush created Drufo. Number 2, Carson Durst was part of a Lush research and development team and conducted a study that discovered Drufo had carcinogenic effects. Ms. Durst testified that she and other members of Lush raised concerns that their fertilizer could cause cancer. Like Duncourt claims, she didn't know if Drufo was carcinogenic or not. She knew that her main product may cause cancer and she didn't look into it. She didn't take the time to read the results of Carson Durst's study. Let's talk about the protective measures that Lush chose not to take. With their knowledge of the possible carcinogenity of Drufo, all Lush had to do was add one more line into the label on their product. One warning. This would have been cheap and easy, but Lush chose not to take a basic precaution. This proves that Lush Fertilizer was negligent in failing to responsibly prevent risk. Number 3, Dakota Weers did use Drufo. That's undisputed. But the defense would like you to believe that she didn't use it in the expected manner. However, because Lush failed to properly test and warn their users, there is no expected manner in which Drufo would ever be safe for Dakota Weers to use. Number 4, Drufo causes cancer. To dispute this, the defense is relying entirely on one study conducted by Dr. Devin Williams. Dr. Williams has evident financial gain from Lush Fertilizer prevailing in this trial. His study was never peer-reviewed, nor can he detail the specifics of it. He even openly testified to having financial bias today in court. Skylar Weirs tried to convince you that Lush Fertilizer is a victim of the old guard of the agricultural industry, and that's the reason we're here today. Dakota Weirs is not now, nor has she ever been, a member of the old guard. Although Dakota Weirs may be diagnosed with non-Hodgkin's lymphoma, it is the greed of Lush Fertilizer that will have killed her. Dr. Williams knows about the causal link between Drufo and cancer and still testifies. His greed kills science. Skylar Weirs knows that her sister deserves justice in this trial. Her greed kills family. Blake Duncourt knew she was risking countless lives when her company chose not to bake the Drufo. That's greed, and it's killing Dakota Weirs. Lush Fertilizer may have failed their responsibility to Dakota Weirs, but it's not too late for you to fulfill your responsibility to her. Find for the plaintiff. Thank you.
Thank you. Does defense ready to give its closing argument?
Yes, Your Honor. Before I begin, can the court see and hear me all right?
Yes, I can.
Someone to blame. Members of the jury, we aren't here today to try and convince you that what happened to Dakota Weirs isn't a tragedy. Instead, we're here to ask, is it Lush Fertilizer's fault? Ms. Dino just got up here and told you today that this case is a story about the way greed can kill. It's not the case. This isn't a story about a corporate money-hungry company. This isn't a story about a money-hungry twin sister. This is a story about a family, a desperate family looking for somebody, anybody to blame. When the plaintiff decided to sue Lush Fertilizer, they took on a heavy burden. Today, they had to prove to you that Lush Fertilizer is liable through a preponderance of the evidence. Meaning, they had to prove that Lush knew their product was dangerous and sold it anyways, and that Drufo, not something else, is what caused Dakota Weirs to develop non-Hodgkin's lymphoma. At the beginning of today's trial, my co-counsel Lily Radowski asked you 3 questions to keep in mind today. Let's revisit those. Firstly, can you trust Dr. Casey Rogers' study? Well, today you heard from Dr. Casey Rogers, who showed you a study the plaintiff wants you to believe shows a clear connection between Drufo and cancer. Members of the jury, as you heard today, that study, it's fatally flawed. Dr. Williams just told you that it wasn't peer-reviewed and it wasn't replicated, both things done within the academic community to ensure that the results of a study are reliable. But more importantly, you heard from Dr. Casey Rogers herself today, the way the study was actually even designed is flawed. She failed to isolate her causal factor. Those farm laborers were exposed to other fertilizers and chemicals that weren't Drufo. Maybe Drufo caused cancer in those farm laborers, but it's just as likely that it didn't. That case study holds no weight. Secondly, could something else other than Drufo have caused Dakota Weirs to develop non-Hodgkin's lymphoma? Well, you heard from Ms. Weirs herself today. She told you she worked at Havens Landscaping for 4 years. And that during that time, she worked with so many pesticides, fertilizers, and chemicals that she couldn't even name them all to you today. Just as a reminder, the plaintiff had to prove to you that Drufo and not anything else is what caused Ms. Weirs to develop non-Hodgkin's lymphoma. But because everything she was exposed to, that's impossible to do. Lastly, we have to ask, did Dakota Weirs protect herself? We understand that it's incredibly hard to look at someone who is sick and to decide whether or not they are at fault for getting sick. That is an objectively hard thing to do. That's not what we're asking you to do today, though. We're asking you to look at the law and decide who should legally be liable. At the beginning of today's trial, we showed you Exhibit 1, the label on Lush fertilizer, that clearly states its users should wear a face respirator and cover their skin. Ms. Weirs told you today that she didn't do either of those things, that her employer didn't force a 14-year-old child to protect herself, that Havens Landscaping allowed a 14-year-old child to work around harsh chemicals day in and day out for 4 years. She should be suing Havens Landscaping today, not Lush Fertilizer. Regardless, it's clear that neither Ms. Weirs or her employer forced her to protect herself. Members of the jury, the plaintiff is looking for someone to blame. But it's evident that person is not Lush Fertilizer. Because of that, we ask you to find them not liable. Thank you.
Thank you very much. And does the plaintiff have any rebuttal?
Yes, Your Honor. Can I get a brief time check?
You can.
Your Honor, I have 31 seconds remaining for rebuttal.
All right.
A money-hungry family? The only money-hungry member of the Weirs family here today is Skylar Weirs. Dakota Weirs doesn't know if she'll get a wedding day or ever be a mother. She's lost all hope. No, she hasn't lost all hope. Greed has killed it. Fined for the plaintiff. Thank you.
All right, let me give a round of applause for all of our participants. What I want to do before we give any comments or feedback is to make sure that all of our scoring panelists have been able to submit their scores. And so what I'll do for the scoring panelists, once you've submitted your scores, what's the best way to do this? I was going to say, let me have you go ahead. I'll let you turn off your camera once you submitted your scores. If you turn your camera back on, then we'll know that you're ready to go ahead and give a critique as a group. All right, it looks like we have all 5 scoring panelists who've been able to submit their scores. Actually, this is a first, and I hate to say this, I actually know what those are because of our electronic scoring sheet. We will get to those in a minute. We're making sure that they're verified and correct. I want to let each of our panelists go ahead and give you an opportunity, give them an opportunity to go ahead and tell you some of their thoughts. We won't spend a lot of time. I'll just follow along the top in the order I see it again. Judge Tao, any thoughts or observations that you have in terms of the performances tonight?
I thought that everybody did an excellent job. I love the personalities that you give the witnesses. Frankly, I think that's potentially even more fun than being the lawyer. But in terms of constructive criticism, the one thing I would suggest on the defense side, I liked your theme, someone to blame, and then your theme got lost in the old guard, new guard thing that kind of took a U-turn. I would suggest pick a theme and stick with it, and don't try to ride two horses at the same time, because generally they diverge and you end up in the splits, and that's very uncomfortable.
All right, Dave, easy enough. Appreciate it. Thank you. For right to the point. Mr. Ritchie, your thoughts, any criticisms or critiques or constructive criticisms?
So very well done. I just feel energized having sat through this trial with you all. You are very talented young individuals, and you put so much work into this. I know, we all know how much work goes into preparing for a trial, and obviously this is different than a real trial, but I know that work is the same, and I'm just so impressed with all of you. You have bright futures ahead of you if this is what you decide that you'd like to do with your lives. That's a long ways away, obviously, but I just encourage all of you to keep with this, because I could not be more impressed. And I mean, I have all kinds of comments. I'd love to sit down and have a meeting with you all so we could collectively discuss some of the strategies, because I think that there were a lot of strategies that went into these narratives on both sides. And I'd really like to talk through them with you and find out whether they were hits or misses. I think for the most part, it was just so well done on both sides. And I just want to congratulate both teams and their coaches and families for being here and getting this far. It's very well done.
Excellent. And for our scoring panelists, we also are happy to facilitate letting you get in touch with teams, or teams reaching out to you to get more detailed comments if you'd like. So we appreciate that. In that case, let me go to Judge Buchanan. Your thoughts? Oops, and you were muted. Sorry, I think I might even be able to undo that. Hold on. Oh, there we go.
There we are. I would just frankly echo the two things that have been said so far. I would be delighted to sit down with the student attorneys to talk about their performances. One thing I guess I say this when I do mock trials, I say it to almost everyone. The essence of being a good advocate is genuineness and authenticity. And you all came off that way, and you're more effective that way. You know, what I say to lawyers is, you're just exactly the right height. You're just exactly the right gender. You're just exactly, you have exactly the right hairdo or haircut. You have the right tone of voice. Everything about you is just right. All you need to do is be comfortable with it and live with it and be genuine. When you're genuine, the jury just naturally wants to believe what you have to say, and you take out any distraction. I too have a long set of notes here, and I'm not going to go into all of them, but I do want to kind of echo what Judge Tao said. When you pick a theme, you do want to stick with it. And the one that kind of stuck out to me was that in opening, the defendant said, "There's no villain here." But it turns out there is a villain. The villain is Haven Landscaping. They sent this poor defenseless 14-year-old girl out to do landscaping without emphasizing that she ought to be wearing protective clothing and all that sort of thing. So it does, you know, it ends up being kind of counterproductive to characterize it in one way like that. The last thing I'll say, and I appreciate your indulging me here. I don't get to talk about this very often. And this is a real challenge in this context where you only have so much time. You have to do things within time limits. And I recognize that what I'm about ready to say is a little bit artificial, but I think it's always more effective to stay away from the conclusion as long as you can during an examination. Lay out the facts. Did they do this? Did they do that? Did they do that? Did they fail to do this? And after you've had the right answers to all those questions, then you can ask what I call the aha question. So Lush has a prioritizes profit over people. Is that what you're saying? And once you've had you've laid all the foundation for it, the jury has reached that conclusion themselves. That's what you want them to do. There's a very wise old trial advocacy teacher used to say that if a jury hears it once, they may believe it. If they hear it twice, they will believe it. If they hear it 3 times, they'll die for it. And if they reach it themselves, they'll die for it repeatedly. Let them get there themselves. Don't, trust juries to do the right thing. Trust them with nuance. Trust them to understand the meaning of the facts that you've painstakingly put together. And then they will understand why you're asking that conclusory sentence or conclusory question at the end. Just an excellent job, all of you. I just can't believe that you're in high school. I see lawyers in my courtroom all the time that don't try a case as effectively as you did. So excellent job. Thank you all very much.
Thank you. Judge Johnson.
I was very impressed with all of your commands of the rules of evidence, the hearsay, 403, 404. Honestly, there's a lot of practicing attorneys that don't get the nuances of those rules as well as many of you exhibited today. That just shows me a lot of preparation, probably a lot of good coaching. So applause to your coaches. As far as constructive criticism goes, what you have to prove is what's in those jury instructions. What you have to prove, the plaintiff, I would have liked to seen a little more hammering on the knew or should have known. For you, this was a battle of experts, putting your expert and your inside science person up against their journalist and their paid off, biased expert. From the defense standpoint, I think it's already been said, your a little bit of a shifting sands on your theme and a little bit of getting away from the comparative negligence, not only from the plaintiff herself, but her company, and pointing the finger at all these other places. Kind of like Shakespeare said, to thine own self be true. You've got to know your strengths. You've got to hammer your strengths. You've got to focus in laser on the weaknesses of the other side, and don't veer from it. You stick to attacking their weaknesses, you stick to promoting your strengths, and then make sure you're arguing those jury instructions, because in the end, that's what it all comes down to. But at this point, quite frankly, I'm nitpicking because you all were all so accomplished and did so well that all I'm left with is nitpicking. So congratulations, excellent job.
Thank you. And Mr. Vinegar.
Yes, thank you, Your Honor. So I want to commend all of the competitors on the effort that they put in over the last year, right? 9 months to a year preparing for this, and for their performances, holding it together today after so many rounds yesterday and today. So you all put on a great performance. I want to call out just a couple performances in addition to all the other comments that the judges have brought up. I thought we saw a lot of great strategic risks. Some of them paid off. Some of them ended up perhaps causing a little bit of confusion for the jury. But one that I thought was particularly clever was Ms. Radowski's introduction when she was working with Blake Duncourt, bringing in testimony about the financial or potential financial bias that the owner of the business would have, which seemed to deflate the potential argument that the plaintiff might want to raise on cross-examination of that witness. I thought that was fairly effective because it kind of took off the edge of what could have been another little chink in the armor. And then also on the closing, I want to point out that it's very easy for the plaintiff to overcook things on the closing. But I think Ms. Dino did really a nice job of balancing, kind of creating the urgency for the jury to really pay attention. And you heard a lot today, but you know what? This is serious. This is about someone's life. And really bringing it back, both with an empathetic style, but then also argumentative, really hammering those points in the testimony that came out that really demonstrated what you wanted the jury to understand. So with that, I think further comments might just be lost because you've heard a lot this evening, but I just want to applaud you all for the work you put in. So thank you.
Are we allowed in other schools now, John?
Oh, in just a moment, absolutely. First, I do want to thank all of your scoring panelists for giving us your Saturday night on a weekend for several hours. I appreciate you being here, and thank you to all of, I know some of them are watching, all of our scoring panelists and presiding judges throughout the entire tournament. Thank you for your students, to all of your coaches and to your parents, the supporting individuals who've done that. And thank you certainly to Amy Shreenan and Ashley Staub at the Bar Association for making sure we could get this done, and all of the assistance we've had from the Bar Association. I appreciate all that. I am not going to waste any time further in terms of going on and on about, I'm not going to waste any time giving you comments or observations at this point. I think you want to know the results. So our scoring panelists know, make sure I don't talk out of hand with this. Make 100% sure. Hold on. Good. I'm correct. Our plaintiff, Team Jim, was Team Mullen. Am I correct? And our defendant, Team Ryan, was from Team Lakewood. Both of those teams were exceptional, and I will go ahead and get to the end. This was a particularly close round. Some of our scoring ballots in this case were decided by a point. It was not unanimous in both directions, and our total point differential was only about 10 points between all of the scores back and forth. It was very close. However, there is a definitive winner in this case. It's a team that went undefeated throughout the tournament. The winner in this case will be representing Colorado at the National High School Mock Trial Tournament is plaintiff Team Jim from Team Mullen. Congratulations. We'll reach out to all of you as well in terms of the schools with that. We'll be getting you analysis and breakdown of the scores and so forth. But to everyone else, thank you very much for your time and for your evening in terms of that. We'll go ahead and be in recess. And congratulations to both teams for an excellent job and for Team Mullen for being able to advance as well. Thank you all very much.
Thanks, everyone.
Thank you.
Thank you so much.
Thank you so much.
Thank you.
Thank you.
Oh, panelists, you guys were fantastic. Thank you.
Thank you all so much.
And I love when Eric, oh good, because he's still here, was like, those were good arguments and objections. He didn't say they were good rulings on the objections. And
But lawyers have to learn how to deal with that too.
They do. But I got to tell you, how many times do you hear an objection on best evidence? That was impressive.
Right out of the gate, yeah.
Right
I can't remember ever hearing one.
Yeah, there were a lot of those tonight.
They were on it. They were impressive.
They were on it.
Thank you.
You did a nice, John. You did a nice job of letting them talk about it. It was really, the back and forth. I was worried initially that it was taking too long, but I think the back and forth was effective because they ended up kind of, responding to one another's arguments, and I think all of them came away thinking this is really more complex than I gave it credit for.
I like that. And my hope was certainly that all of you then got to just, did they really know the rules of evidence, or were they just, parroting off something and they could just say hearsay, but then couldn't express what that meant? So Mostly they were pretty good with that.
John,
Damn
I
good.
think you did do a very good job, and really, I think the rulings were meant. I mean, obviously, like you weren't going to deny someone's ability to testify. So some of the even though I think sometimes in reality you would have ruled differently, but you did it really well to make sure that they could present their cases. And I appreciated the fact that all the little sidebar things, because quite frankly, that's kind of what it came down to.